Up for Girl Scout cookies. Please be generous. You got that, everybody? All right, you ready?
I am ready.
You
Should
got
give us
the
some
sheets?
paperwork. We're all good to go.
Okay. Open the hearing on House Bill 548 relative to the definition of compliance with a legal support order for child support payments. The chair recognizes the chair of Fish and Game, James Spillane. Come on up.
Thank you, Mr. Chair, members of the committee. Took me a minute. I had to get through the three and figure out which one was the one I was bringing up. Because I have three of them here today, but this one, I'm going to tell the committee that I would welcome an amendment if they so choose, because the first cross out that's on line 5 was not something I did, and we don't know how it got there from OLS unless the department asked for it. So if the department had said they wanted it, they didn't tell me about it, but it was in here and it shouldn't be. That shouldn't be crossed out. The only thing I'm doing here is adding a definition of what it means to be in arrears by setting a baseline of $25. And the reason I'm doing this is because last summer I was denied a passport from the federal government, Department of State. My wages are garnished automatically. I'm like, how could I possibly be in arrears? What they do is they take how much would you pay at the end of the year total, and they divide it up by how many pay periods you have, and that's what they garnish out of each check and send along. So currently, the way the law is written, as soon as Division of Child Support becomes aware that you're in arrears, they have 30 days to tell the federal government you're in arrears and you lose your government services. It's not just passports, but lots of other things. I'm sure the chair could enlighten you on the different things the federal government provides that you could lose. And it could be 1 penny. And for me, it was a rounding error because my pay periods didn't hit at the exact time that things were due. And when you added them all up by the end of the year, it's totally equal. But I had to go online with Division of Child Support, make a payment to them in addition to what was normally being taken out of my check, just to make myself go to exactly zero, so I could then contact again the State Department and tell them, would you try processing my passport again? And now at the end of the year, I'm going to be overpaid, and Division of Child Support is going to have to either roll it over or send me a check back for the difference, because the whole problem here is the small amount, a penny, can kick you into the federal government. And when I talked to the State Department, they said, the way the system's set up in New Hampshire, all we get is a red light or green light, a thumbs up, a thumbs down. When we ping the system, if they're paid up to date, we get a green light or a thumbs up. And if there's an arrearage, thumbs down, we can't process it. For a few pennies rounding, I'm sure this happens to other people, but I wanted to set a baseline. And so the researchers down at OLS did some research to find out what is the minimum amount that somebody might have to pay for a month. And $25 was the smallest amount that somebody has to pay for child support. So this would mean that that seems to be a good number. That if somebody's in arrears more than 25, now you can notify the federal government because it's actually a missed payment or something rather than just a rounding error. And that's all I have.
Any questions for Representative Spillane? I'll be happy to, yes, Representative Bickford.
You're using thank you, Mr. Chairman. Thank you. You're using $25, and they said that was the minimum. My experience has been it's usually $50. And did you ever think of using maybe one payment?
I did actually say one payment, but it varies so much from individual to individual what one payment is, that it would have actually been a higher burden to the department to try to figure out what one payment for each person is, rather than have a specific dollar amount, is what I was told. I asked all this with the researcher. We went back and forth a few times because at first I just said, it needs to be set up so that it's an actual missed payment before you penalize people. And that this is what they came back with.
Thank you.
Representative Raymond.
Thank you, Mr. Chairman, and thank you, Representative Spillane, for coming and for taking my question. So I'm still confused about how the red light, green light thing works. So if someone makes a payment for, say you make your paid biweekly or whatever, so you make your payment this Thursday, it gets taken from your check. Are you now in arrears until your next pay period?
So
Like, how does that?
this ties in with the other bill that I had tried to put in for accrual dates being able to be
Right.
chosen. Whenever they hit their accrual date, where the department says, okay, it's due now, however much they've been sent counts towards that. And if it's off by a few dollars, you're in arrears until
Got
the next payment comes from your company that kicks it. Now you're over.
Right.
And so at various times throughout the year, you're over, you're under, you're never dead on.
That makes sense.
And over doesn't harm it. Over is a green light, but under is not,
Even by a penny.
even by a penny.
Thank you for that. I appreciate it.
Okay, thank you for your testimony. I will trot down to OLS and get an amendment, and the amendment, to be doubly sure, simply takes the strikeouts in line 5 and 6 out and keeps the text.
Correct.
Thank you. Will do. All right. I have one other pink card, and it is Matthew Hayes, Bureau of Child Support Services. With a McPherson tie, is it? Clan McPherson? Looks familiar.
Nautica, Mr. Chairman.
Oh, sorry?
I've got a Nautica.
Okay.
Thank you, though. It is a nice tie. Appreciate that.
It is a nice tie.
So thank you. Good morning, Mr. Chairman. Attorney Matthew Hayes from the Bureau of Child Support Services. Thank you for giving us the time to speak about this bill. I am here with the Director of Child Support, who I think you may have met before at the orientation. I'll let her introduce herself real quick.
Good morning, Mr. Chairman and members of the committee. My name is Lisa Dekatowski with the Bureau of Child Support Services, Bureau Chief. Thank you.
So we were here to testify on this bill and provide some information, but the bulk of my testimony is actually geared a little bit more towards the portion that it seems like is not going to be moving forward. I was going to talk most about why we would like to have the medical insurance piece that was going to be repealed left, but it doesn't sound like that's going to be an issue, so I'll not talk about that. I do have written testimony prepared, as I usually do. It does talk about that. I can still give it to the chair, to the committee for the records if they wish. It sounds like most of the discussion from the sponsor was about the obligor's arrearage and change or adding a definition to becoming in compliance to be if the arrearage is less $25 or less. I would say that there will be some system changes involved with that from a software standpoint, as well as changing costs associated with changing internal policies and forms. I wasn't gonna say that. I guess I was curious what the reasoning was behind it, and I just learned about it just now. So I have some. I'm more prepared, I guess, to answer questions about arrearage and compliance of arrearages. I'm not sure if I'm prepared to speak completely to everything that was just discussed because, like I just said, I didn't really know what the reasoning was prior to coming here. So I don't know what the committee would find most helpful. I guess Lisa, do you want to add something about the thresholds or just take questions?
Well, we could certainly take questions from the committee.
I think we'll just take questions.
Okay, great. Any questions? Representative Craig?
So, thank you. Yes, Chair. Thanks, Pat. And thank you for taking my question. Sorry, it's a Monday, Tuesday, right? Anyway, I guess I was curious. So from your department, do you see,
I don't hear that you have any issues with this if we take that strikeout, if that stands. Is there any issues from the department on something like this?
It sounds like the medical support piece, so the lines 5 and 6 are not going to be taken out, so that's good. We
Okay.
want them to stay.
Okay.
As far as line 15 and adding that piece, our position would be that we would like that not to be added, but I don't know if I can point to a 4D issue necessarily with, when I say 4D, I apologize. I mean a special provision in the federal government's CFRs that tell us how to set up our child support program. I don't know, I'm not aware of something like that specifically being addressed that I can point to and say that it's going to be contrary to federal law if you add this. But I can tell you that it will require us to make changes to our system and changes to our policies. And I can at least say that it could cause some difficulties with the last payments. So if, for example, somebody was owed, a parent was owed, not the state, but if a parent was owed $25, we need to collect that $25 for them. I know it doesn't sound like a lot of money, but it's owed to that parent, and we need, in order to complete our mandate and to close out the case and to actually completely have all the arrears paid off, we need to make sure we collect that $25. So, in theory, I can see it being complicated in terms of not being able to use our general enforcement remedies to collect that last bit of money for that parent. There's that as well. I can't imagine that's too many cases, but there is that issue. It could-
Okay, thank you.
Thank you, Mr. Chair. Thank you for taking my question. So, in the case of a wage garnishment, and I just would like to make a disclosure, I am a co-sponsor on the bill, but I do not intend to testify. So, but in the case of a wage garnishment, that $25 will be paid with the next garnishment from the individual's paycheck. So the system will receive that monies. Isn't that correct?
Yes, if there was a wage garnishment, it would be collected. I think it probably would only come up if there's a situation where we didn't have a wage garnishment. Somebody was self-employed or we didn't know where they worked or something like that. But yes, if there was a wage garnishment being collected, it would be collected at some point. The compliance piece is only if somebody's not making payments for a long period of time. But thank you
Thank
for
you.
the question. Yes.
No, thank you.
Any further questions? Oh, Representative Raymond.
Thank you, Chair. So I feel like I have to stretch really hard, and I apologize to everyone. I just want to be seen from the corner. My question is pretty much the same as what I had asked Representative Spillane regarding, I'm still unclear. If someone's wages are being garnished by their employer, one would assume that as long as they're receiving a paycheck from their employer and working, that they would never fall into arrears. So I want to understand how not changing the system could impact, something like this happening again. So it makes sense to me, this idea that if you divide up, the payments over 52 payments or, 26 payments or whatever it is, that you might have the payments be off by a couple cents each time. That makes sense. But I guess what I don't understand is what other type of solution there could be to the issue of someone, say, not getting a passport or having some other problem with the federal government because of a rounding issue that has they've not done anything wrong. Because we don't want to penalize parents who are in good faith cooperating with the system to make sure that the other parent has what they need for the children. So, are there other options? What can we do? Would a different number help? I guess that's my question.
Thank you, Representative Raymond. If I may, I would like to clarify In the first instance, I'd like to just make reference to the federal offset program that you have referenced, as well as Representative Spillane. The threshold for the federal offset program requires an arrearage balance to accumulate of up to $150 worth of arrearages due in a public assistance case, so arrearages that would be owed to the state of New Hampshire, in order for that threshold to be met for an individual to be submitted to the federal offset program. In a circumstance where an individual is not receiving public assistance, the arrearage balance would need to accrue up to $550. So there must be that balance due in arrearages. So not, payments that had not been made up to that value before the individual could be submitted for that particular enforcement remedy. Certainly in the event that an individual is paying by an income assignment, then they would, if they've already been submitted for that previously, once you are submitted to the offset program until your arrearage balance is satisfied with a zero balance at the end of the calendar month. So I do believe that that may have been the circumstance that the sponsor had been speaking to previously. Unfamiliar with those circumstances, this is the first that our Bureau is hearing of this today, so feel unable to best respond to that specific incident. However, in terms of just arrearages in general, the Bureau, when the Bureau of Child Support Services enforcing an order for child support, we look at what is due in the month. So if an individual has a certain monthly support obligation that is due for the current month, anything that is unpaid goes into the following month and is considered arrearages. What we would consider our enforcement activities for those arrearages would not initiate until there was a consecutive non-payment of 60 days. So if we hadn't received any payments on any current or on any arrearages that were due for a consecutive 60 days, then our enforcement activities would not or our enforcement activities would be initiated at that point of non-payment. So in a circumstance where an individual is paying by an income assignment, it may be a situation where the amount that is due for the accruals, the amount that child support is to be paid, versus the way that the payments are coming in, there may be some balances due that carry over. But again, as long as there's an income assignment in place, we would not take any enforcement activities on that.
Follow up?
Follow up?
Thank you. So in that circumstance, say for example, someone has an arrearage and then they come flush. So they've discovered that they owe and now they have paid in and they're back to zero. Mm-hmm. Is the threshold another 60 days before another contact with the federal government for enforcement, or is it from then on, if you're even like a cent behind, you're going to be reported?
The threshold is always to the arrearage balance, so that the arrearage balance is set at that $150, and then the $550, whether you're whether it's arrearages for public assistance versus non-public assistance arrearages. So it's we report that information to the federal offset program at the end of every calendar month. It's built in, so once that reaches zero, then that information gets reported. If there are circumstances where there may be a timing challenge there between how our automated system reports that information, then the Bureau is willing to work with the individual and with the federal offset program to help to satisfy that arrearages that are due.
Thank you.
Actually, I have a quick question. Is this something that you could do with your system on garnished wages, knowing that, I mean, you must know what week is gonna be $10 short or $5 short. Is that something that you could do in your system itself? On a week-to-week basis, knowing, okay, this is $5 short this week, however, next week it's gonna be over. At the end of the year, they're gonna be even.
Thank you, Representative, for the question. So our income withholding, the system is currently set up. If we were able to identify the frequency of the payments, which I think is very difficult for us to assess and evaluate if we don't know if the payments will always be regularly paid through an income assignment. So each case has to be looked at individually to be able to make that assessment and determination.
Representative DeSimone?
Thank you, Mr. Chair. I'm really stuck on the fact that an individual is involved in a wage garnishment. So that individual has zero power as to how often the payments are made. It's just garnished from his or her wages. Yet, an individual can be penalized by the federal government for being behind for just a few cents. Isn't there a way, you're talking about your quote unquote kind of discussions with the federal branch, but if this person is denied a passport because of a few cents, isn't it counterproductive?
Thank you, Representative. I appreciate the question. Again, I was not prepared to come here today to speak fluently in regards to the federal offset program and how that particular program works. I'm certainly willing and able to provide the committee more information in reference to that. Certainly, if an individual is certainly if an individual had previously been submitted for the federal offset program on an arrearage requirement and met that threshold to pay the arrears that were due and are now currently paying their current and ongoing amount by a wage garnishment, the Bureau would take those facts and circumstances into consideration and look at all of those circumstances again on a case-by-case basis. I believe that it is difficult for the Bureau to state one way or another whether or not it is certainly a hardship, as you had referenced, for the obligor, the individual paying. Again, keeping in mind that our role is to collect and enforce on current and arrearages due for the families that we serve and to assist with the obligors in engaging. And if there's an income assignment holding in place, we would have to take that into consideration. Thank you.
Any further questions? Representative Panic?
Thank you for taking my question. How long does it take from the time you notify the feds and the feds take off the no-fly list restriction?
So the thank you for the question, Representative. Appreciate that. I would need to clarify the specific time frame for you and get that information for you. There is, again, there are specific requirements in relation to the federal offset program and the passport denial program. Both are different in how those are satisfied, and the transmissions that go between our department and the Federal Bureau of Fiscal Services is electronic, and there is a there can at times be a delay in processing. It's all dependent upon how the Federal Bureau receives that. I would need to get that specific time frame for you, though. I don't have that available.
I have a follow-up question. So in essence, what you're telling me is that the person is up to date, the time that it takes your organization to notify the feds, and they're up to date, they still can be penalized and not be able to get a passport or leave the country, is what you're saying.
Thank you, Representative. I appreciate that question also. There is a process in place that allows us to communicate directly with our federal passport partners to inform them that an individual is in compliance. There's also a telephone number and a process where the individual who's responsible to pay the obligor in the circumstance can also contact them. And we do try to work with our obligors as quickly as possible to get them that information when they become in compliance.
Thank you.
You're welcome.
Any further questions? Seeing none, thank you. Oh, was there another one? Representative Bickford.
Thank you, Mr. Chairman. And thank you. I've heard a couple of numbers here, $150 and $550, depending on whether it's public assistance or otherwise. And so I'm curious if that would be a better number here. And whatever we do here on this line that we're talking about, is it going to cure the problem?
Thank you, Representative. I'm not really sure how to answer that question in terms of what is the best. I did not have an opportunity to consult with the sponsor prior to the creation of this or have any input previously prior to this. So I think that certainly, the Bureau would have to take your question into consideration and determine what may be a best solution to this circumstance.
Well, how much time do you think you need?
I'm not sure thank you. I'm not sure how to answer that in terms of time. I guess
Depends what the
Well,
we're not going to make a policy recommendation on this legislation, I guess. Our position is it would be better to not have that provision there, is what I said at the outset. If the committee needs additional information on the federal offset program, they certainly do that, and they could take that into consideration when weighing this policy decision. But I don't know if we are able to comment on whether or not we could change that threshold level.
well, maybe clarify, if I may. I'm just asking what would fix the problem, not what you want.
Well, I think that what we're explaining with the terms of the offset program is, those are federal requirements that are placed upon us, that very much automated process. And this legislation generally deals with how New Hampshire deals with whether someone's in compliance or not. So we would still have to report these figures to the federal government regardless, would be my understanding of the offset program. So, and just in terms of arrears in general, I know that a lot of questions come up with arrears. 60 days in arrears, 60 days non-payment, and I think we talked about that briefly as well. Someone could be in arrears and still be in compliance. Someone could get an order today that's retroactive a couple months ago and be in arrears and be in compliance and start making payments, and they've done nothing wrong. But the figures still need to be reported to the federal government, and that's a requirement of our program. So I don't know if we can make a recommendation on what to do, if anything, with line 15.
One more. When we passed, and I was here, when we passed wage garnishment, and I fought it quite a bit because it's very draconian and it only takes certain people. The people from Boston came up because this committee was not very enthused about it. And so the folks from Boston came up and said, you don't pass this, you'll lose $21 million of your Social Security 40 money. But we found a way to have another way of doing things, which is to have the accounts that people can, in other words, it's not totally mandatory because we found a way to do it. And that's why I'm asking you, try to find a way to fix the problem with the feds, because we got to do something here, I feel. And it may not be quite the right thing. So I'm asking you again, try to do something like we did before. Thank you.
Any further questions? Seeing none? Thank you.
Thank you.
The last card I have is Vivian Gerard.
Thank you, Chair and members of the committee. My name is Vivian Gerard, and many of you have known me as the Silva v. Silva case. I've come up here and spoke with you many times about this very issue. I am appalled that child support can come up here and lie straight to all of your faces. Child support does not follow the court orders, and in my next testimony, I do have all the backup documentation.
So we're talking about
The
House
wage
Bill
assignments.
548?
Yep,
Okay, not wage assignments, but
Well-
the $25 total amount of arrearage.
correct. And if you follow where I'm going, you'll see where I'm going with this. So child support says in 60-day window to pay partial. But what they don't look at is the people that pay, that have the ability to pay and have thousands of dollars in non-compliance. The compliance with legal orders of support is also what they say that they follow. And I can certainly show you many documents here where they've changed the court orders, they've changed the wage assignments, they don't follow
So
what
is
the
this in
court orders
reference
read.
to wage garnishments?
Yes, and if
It
you
is.
look at, yep, and if you look at the wage garnishments that I have here, I have their audit, I have the previous, give me 1 second to find it here. So I have the court orders that say what the amount should be garnished from the paychecks, when they were supposed to start. I even show the fact that they say that they're gonna take X amount of money out every single month, and that's not what they're doing. They make up their own rules. They say that they're in compliance with the legal orders of support based on their bill here. So they're saying that they are following court orders, ongoing payments but they're not being followed based on child support. They do not follow it. Child support is not being held accountable for the following court
Okay,
orders.
I'm not seeing where this ties into the,
So if
to the
they're
bill.
saying that they're taking out wage assignments,
So
for
this
instance,
so this person that was getting garnished, wasn't able to get his passport, wasn't able to fly, wasn't able.
no, that's what
Okay,
that's what I'm trying to
that's-
get to. So in my case, there's 46, actually it was $51,000 that were all based on child support arrears. Not once was the person losing a license, losing a passport, never got any type of enforcement, even though I have a letter here that says child support is enforcing. So I'd like to know, they're up here saying that this stuff is being followed, this stuff is happening, but I can show you clear documents right here, which you're going to get in the next package, that they are not following what they're saying that they're in compliance of doing. They're up here lying to your face saying that they are in compliance, they're following orders. and
Okay,
they're
the
doing
chair is
wage
going to
assignments.
intercede here and say, this testimony I rule out of order. It is not to the point. It may be to another point. It is not to the point of this bill. So please take your seat.
It's based
In the
on wage
future, make
assignment.
sure it is dead on, accurate, and brief.
Well, if you look at it, it says right there about the order of support.
You may hand out what you wish, and please take your seat.
Yeah, this closes the hearing on 548.
The next hearing is scheduled for 10:10, so we will take a break until then.
Gonna do it right after the hearing. Oh, it's
Chairman of Fish and Game, Representative James Spillane.
Thank you, Mr. Chair, members of the committee. I brought this bill originally. My intent was to try to change things so that we were not forcing everyone into wage garnishment automatically. I have a good working relationship with my ex-wife and was paying her directly while we were, before the final divorce orders came. But when the final orders were given, I was told you can't send her checks anymore. Now you must automatically have the state handle it. And I'm like, why? And then that, because I wasn't in arrears. And I always thought that garnishment was something that happened because you were in arrears or you were undependable, what have you. Not somebody who was in good standing and making the payments all the time. But we did the wage garnishment, and it didn't become a problem until my son wanted to go to summer camp, and my ex-wife contacted me and said, hey, can you pay a little in advance to make sure that we can put the deposit down for his summer camp? And I said, I'd love to, but I talked to DC, the Division of Child Support, and they said, we don't have a capacity to handle an overpayment. So you can't send us extra to pay to him up front. If you overpay, we're going to send it back to you. We don't know how to handle an overpayment. And if I pay out of my pocket, there's no record that I made that payment except for my own check stubs. And then it wouldn't be credited towards my regular child support. So I'm like, this is annoying. Maybe I can fix it. Turns out, and I know more about it now from Rep. Bickford talking about when you passed the wage garnishment. Federal law prohibits us from making it an option, except that an option does exist to not wage garnish if both parties agree to it. That was news to me because in our divorce process, we were never told, hey, you can avoid wage garnishment if you both agree to handle it yourself. If you both sign the thing saying that you want to handle it, you can handle it. And so instead of making wage garnishment optional, I was going to do it so you could opt out of wage garnishment. Found out that's not really in compliance with the federal law. I instead changed this bill to basically be an information one. And it instructs the court that during the divorce proceedings, they shall notify both parties that they can opt out of the wage garnishment if both parties agree. So it informs them of their right to not have the state get involved if they don't want the state involved in it. With an exception, because I realized there's 3 exceptions that we need to keep in mind, so I put 3 exceptions in here. If either of the parties lives out of state, it won't be an option. That's just a collection issue. If there's a protective order in place, this will not be an option. That's a safety issue. And if there's a history of arrearage already for child support, it will not be an option, because that's where garnishment becomes important. So what you see before you now is simply a bill that says that the court shall notify every person in their final divorce decree, if there's child support involved, that they have the right to make an agreement between themselves, both parties, to handle it another way if one of those 3 conditions is not applicable. And that the court shall also further tell them that if they choose that route, they're responsible for keeping records of their payments and be able to prove that they made payments on time and all of that. And that's it. I'll take any questions.
Representative Bickford, you bring a historic knowledge of this subject to us, having served here before.
Well, actually, I was on Child Family Law 10 years ago,
That's historic.
but I was there for 12 years.
That's historic.
Oh, okay. Thank you, Mr. Chairman. Thank you. Generally, we don't write a bill that says divorce hearing. It would be for any child support issue, which would be unmarried or otherwise married, and I can't remember the language. It should be. Do you know who the attorney was that wrote this?
I do not remember.
Oh, okay. I think there's a number here somewhere that would identify it.
There is.
Um,
I don't know what they mean, though.
I,
But if I
Sure.
could continue answering, and I thank you for the question, I wanted to, the reason it said we put in the divorce hearing was because we wanted people to know right up front before they get into the child support system that they have the option available to them if they so choose it. It's written into our law, but nobody tells you you have that right. And so all we're trying to say is right up front, let's let them know. I certainly wouldn't object to any time a child support hearing comes up that is also notified that they have the right as part of their child support to make that choice among themselves as adults with children that they both co-parent. But that right exists in our law. I'm not giving them the right. They already have that right.
Yeah.
I'm just saying, let's make them aware that they have that right.
thank you, that's a good idea.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. I just have, out of curiosity, question for you because my husband paid child support by giving a check every month directly to his ex, and they then would also, have these expenses that would come up, camp or half of a copay for medical purposes, and then he would just give her another check, physically hand that to her. So in your example, how would that payment for camp be provided to your ex?
I just gave her a check.
Yeah.
I mean, it was more important for him to go to camp than for me to get it credited, but I found out that it was just kind of annoying because she was asking me to just pay up front a little more extra. We didn't need to have additional child support to cover this.
Right.
We always split those expenses.
Yeah.
And I was going to pay for half the camp anyway, but she needed help with her part of the half of the deposit, wanted me to pay early, and it wasn't an option that was available to me to be credited. So it went uncredited.
I understand. Thank you.
So this has nothing really to do with deadbeat dads or
No,
the
it has.
department not doing its job or anything. This is simply communicating something that we legally may know but probably wouldn't guess. So now we simply told it.
Exactly. This is just letting the two adults with their co-parented children make a decision how best to handle the transfer of payments from one to the other, and whether like I said, it's all written in the RSA already. They have the option to both agree to go outside of that system, but we're not told that right exists.
Did you do any looking around to see what some other states do? Because having lived in several different states and having numbers of people under my care, this was how it was done. One of them gave the other one a check, and only if somebody got really bad did they have to garnish wages.
And that was my understanding, Mr. Chairman. Thank you for the question. And I was confused that I was being garnished immediately. And it turns out that Rep. Bickford could probably tell you more about this, but the feds changed their regulation and the state was okay with it because the state gets money for every case they handle. So the more that go through the wage garnishment, the more cases they handle and the more money comes in from the federal government.
You said the state changed its way of doing it.
I'm not sure when, and that's a history question.
Yeah,
I
but
can't.
what did they change? Did they change that you cannot agree to do it the way you want to? Did that come off the table now?
As Rep. Bickford started to testify, the federal government came in and said, you're going to lose all this Medicaid money if you don't garnish.
Yeah, but that's not saying you got to garnish. That's just saying we're going to threaten you if you don't.
So that was the discussion that happened here that he talked about, and you guys passed a law that said that now we're going to garnish.
But it's still legal in New Hampshire to do otherwise.
If both parties agree.
And this is just
But
cementing
nobody
it.
tells them that they can agree
Okay.
to do it.
Okay. And am I right in saying that you, in anticipating somebody might find an outlier case where this wouldn't be a good idea, you put in brackets 4, 5, and 6 to say if people are in serious arrearage, if one person's out of state, if there's a protective order. So you are answering in anticipation of those who say there might be some realistic objections or exceptions.
Correct.
Okay.
I've hopefully covered those exceptions where we would really want to make sure that the state does handle the payment processing.
I just wanted to get fixed in my mind what we're trying to do here. Last call. Any other questions for the prime sponsor? Seeing none. Now, thank you. Those who are coming up next will address comments to this specific bill, to these specific issues, or you will be out of order. We will not entertain stories of what the department did or didn't do, and horror stories and people you know and you yourself. It will be about this bill, or the gavel will fly again. With that, the chair recognizes for 3 minutes Vivian Gerard to speak to this bill.
Thank you, Chair and members of the committee. As you are all talking about, again, the wage garnishments, and at the time of divorce, people do get assigned whether they're have to pay Child Support Bureau or if they pay directly to the payer. At the time of my divorce, my ex paid me every single month exactly what that court order was. As my cases went on and he was ordered one amount, we went to the Supreme Court. It got overruled 5 times. Every time that order changed, the last time that it was changed in 2018, Supreme Court remanded and made it payable to the Child Support Bureau. Again, and I agree with the previous statements that every time they get any type of wage assignments, they get credit for taking in all these arrears. And that was going to be one of my questions is, if they're constantly showing arrears on my ex's case, why are they not collecting the exact amount of money that he should be paying? He has plenty of money to pay the wage assigned amount. There's no enforcement happening. I'm being told that there's 2 types of cases. One is a wage garnishment, which is a collection agency only, and there's a Title 4D. And unless if you're Title 4D, there is no enforcement on these orders.
So how are you objecting to this bill?
So I feel that basically on this bill, they're trying to enforce things and say that garnishment of wages that become mandatory and both parties to detail their preferred form of payment. So if we had a preferred form of payment where I actually got the check from him, then I wouldn't be dealing with 2018 to 2020, them taking out the wrong amount. He would have been told to pay the $16.66 per the court order, and then somebody in child support put that whole case on hold. It was not their job to put it on hold. Their job was to follow the court order. So from 2018 to 2020, and I have copies of this here.
But
that just show that.
What would you change in the bill?
I would change the fact that if 2 parties are willing to pay that amount, that in my case, at first it was $16.66. If he paid me the $16.66, I would have been getting that money right along on
Okay,
time.
that's the bill. That's
Right.
the law. Your objection is somebody didn't follow that, and that is not germane to the bill. That is a complaint you have against somebody who didn't do their job.
But what I'm saying is if the bill wasn't forced to pay child support, he would have been paying me directly, and he would have been on time every time because he had plenty of money to do it.
So if you 2 agreed to that, then it would have happened, and that's what this bill wants.
But the bill, what I'm saying is somebody in the Title 4D through the state, somebody is changing my case.
Okay, that's
because-
not the bill. That is your case.
But the
That's,
bill-
yeah.
But
go
the
ahead.
bill shows, let's see here. I saw it on here. So first of all, like on part of this, it says that they shall notify both parties. That
Okay.
hasn't happened.
Okay, that's not the bill. The bill says what they should do. If this didn't happen, you have a beef with somebody, but it's not here. You're one non-germane statement away from ending your testimony.
Okay, well, I'm just letting you know that I think that by passing this bill, I think it's going to be another whole slew of problems that you guys are not anticipating. I've been living this for 9 years, and I just feel that by you guys not understanding what is happening on the real side of life from people like me, and
Okay, thank you. I've shut your mic off now, and I would simply say that having gotten to know my committee, I think most of us live on the real side of life. I think most of us have a backstory. Most of us have some complaints or have close loved ones who do. The chair now recognizes the Honorable Betty Gay, alumna of this committee. Time to speak, 2 minutes.
By the way, Jody, if you want to get your mic close to you, we could hardly hear you last time. So I'm just going to comment on a reference that was made a few minutes ago about the choice. It sounded like it was, the statement was that there's really no pressure to make people go through the state when they pay child support. But it's financial pressure that exists. And in previous bills, there's been an attempt to simplify child support so that the person who pays the less on shared support, the person who pays the less is subtracted from the person who pays the most, and you just have one smaller check being submitted. However, in real life, we're always trying to protect our budgets, and whatever dollars we can get from the federal law are really attractive. So it means we constantly have this pressure from federal law to collect and have the money go through our child support. So that is not minimal kind of pressure. There's going to be all kind of encouragement to get people to do that because our DHHS has to pay the bills. So I just wish that we could change the federal law so that we don't penalize our own people, making them go through extra steps. So that's really my whole comment, that is a big pressure.
So your comment is really to the federal law, but
Well,
how about to the bill?
Well, the fact is that the bill is trying to make sure people know that they have an option not to go through the state. But I think it's necessary to point it out to people because the default is, oh, you will pay through the state. Excuse me. There is protection for people who are worried about not being paid to have it on record. But as Representative DeSimone can tell, there's been real efforts in the past to free people from this federal pressure. But money talks and everybody has a budget.
Will you take questions?
Sure.
Does anyone have a question? Thank you and welcome back.
Thank you.
The chair recognizes Lisa. I was saying it so well in my head. Dekotowski. And I'm going to get this one. I know it. Matthew Hayes.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, members of the House and Children and Family Law Committee. On behalf of the Department of Health and Human Services, Bureau of Child Support Services, thank you for letting us speak on HB 618. I guess two things. I think at the outset, there's a number of changes that are being proposed in this bill. I just kind of want to focus on two things, and I have written testimony I can submit after. And it wasn't talked about a whole lot, I don't think, by previous testifiers, but at lines 13 and 14, with respect to changing the amount of arrearage that has to accrue before a wage assignment that was previously foregone can be initiated again. I can explain it more in my written testimony, but that would run afoul of a CFR that requires all states to have that threshold be 30 days. And that's why it's in our statute now written that way.
All right, before you go on, I want to nail this point down while we're doing it. This is when arrearage period amounting to the support owed for 2 months or more has accrued. Is it the line item? Mine are not numbered on my text.
Oh, sorry. Yes.
No, that's fine. 2 months, and you say the Fed standard is 30 days?
Correct. And I had the CFR site in here that everyone can look at later.
We can fix this.
So
Okay, we'll take that problem out away.
and I don't know if that wasn't really discussed before. So I know it sounds like a lot of it sounds like the spirit of the bill is getting information to parties about child support and their options. And I think that we can say that we think that's a good idea. I don't think the Bureau has, our position is that we have no issue if people want to agree to have their own direct payment arrangement created. And as we've mentioned before, I think in the past, there's many orders that we never see. It's only when someone asks for our services and when there's state assistance being provided. And then, we can get into a whole host of laws that surround that. But that's generally it. I mean, and it says right on the uniform support order, paragraph 8, and I can provide a blank copy of the USO after this via email for the committee's reference. But it says on the USO, paragraph 8 basically gives the court that space to make the determinations that, by the way, those determinations are also in federal law, ways to not have a wage assignment if that's what the parties so choose. So I don't think there's any issue with that. I think probably the only other concern that we would have is with respect to us developing a form. I don't know if we would be the best person to do that. I think that everyone's case is different. Every parenting case, child support case, it says divorce case in here. I think Representative Bickford pointed that out already, though. There are other types of cases that come before the court that aren't necessarily divorces. I don't know if we would be able to develop a standard form that would address all contingencies. I think that the spirit of it is well-intentioned and that makes sense, and the more information people have about how child support works, I think would be advantageous to all parties, and I just don't know if we would be able to develop a form that would appropriately address those contingencies. I think that might be best left to the court to explain when the order is issued. Also, counsel for the parties, if they have them, probably should give them an idea of how child support works. We're certainly free to be a general resource if parties wish to reach out to us. I know the court, I don't know what the early stages of the court's divorce proceedings are, but maybe there's a way to provide them with our information so we can give them some ideas about what we offer if people wish to take advantage of it. But unless we get a specific application from a party, we really can't talk to them too much about their case. And we don't provide legal services, so I really can't give them advice either. But yes, the more information, the better. I think we could agree that the more the parties know, the better that the proceedings go. So would you like to add something, Elisa? Then I'm just happy to take questions at this point.
Any questions? Representative Bickford.
Thank you, Mr. Chairman. Thank you, Mr. Hayes. On line 15 and 16, it appears that that's not, I don't see it in the statute. And do you see that as an addition, or is that somewhere in the statute that I'm missing?
Thank you for the question, Representative Bickford. I agree with you. It's not in there. Those are additions. I didn't speak about them because I don't know if there's necessarily a programmatic issue with those. I don't know if the federal regulations and our state plan address those contingencies, so I wasn't going to make an issue out of them. I would say that I do talk about it in my written testimony, but it would involve adding procedures, and there's be a cost associated with adjusting forms and our internal policies. But I don't know if there's a programmatic concern with those two provisions, at least.
Well, thank you, Mr. Chair. I'm concerned with adding more to that statute without having more discussion about it, I guess. And I did see the 2 months as opposed to 1 month here in the statute. Are these the only things that are, that's actually changing the law. This goes beyond notification to the parties. So that's my concern. My
you-
preference would be to strike the additions in the law.
If I may respond, Mr.
Please.
Chairman, are you referring to? I don't have the current statute in front of me, but are you referring to the fact that maybe because I picked up on this as well, that those two additions sort of change the notice and the notice requirement that is found in the opportunity to contest paragraph?
I'm looking, if I may,
Because it's sort of the way that it's written does sort of change how the current statute's meant to be written in terms of notice and opportunity to be heard. That's what you're referring to. I agree. Drafting wise, it could be problematic.
well, it's the out-of-state thing and why that's needs to be there. On line 15, even 16 for that matter. I don't see it, those in the statute, or maybe
No, it's an addition from the bill.
excuse me?
It is added, and the bill does add those two. They're not there before. So that would be a new requirement. Yes, it would. I imagine it would expand wage garnishments. But again, I think that our position is that that would be a policy decision for this for the legislature. I think I was going to comment
Yeah.
on those. from
I
a-
just want to know if we saw things the same.
I think we do, sir. I agree.
Okay, thank you.
Any further questions? Seeing none? Thank you.
I don't know. I would suggest, Representative Spillane, that you take counsel with counsel on the way to walking to OLS to certainly change 2 months to 30 days, which I don't think we would have any problem with doing. And yeah, see what they can, what you want to do. I missed part of it. I do like the 3 carve-outs you made in here. I think that makes the bill good, better than it could have been. But yeah, if you would not mind walking down to OLS and doing an amendment on that, we can have that presented when we exec the bill. With that, I bring the hearing on House Bill 618 to a close, and we have about a 7-minute recess before the stated time for the next bill. And if you haven't yet bought your Girl Scout cookies, you can do that. Did you sign up for some Girl Scout cookies? We're going for the state record.
We will go for the state record. We'll be back as soon as I get to make them.
Chair now opens the hearing on House Bill 583, an act relative to the termination of child support, and calls upon the bill's prime sponsor, the chairman of Fish and Game, Representative James Spillane.
Thank you, Mr. Chair, members of the committee. I'm glad you're still entertaining me here this morning. This one is probably going to be the most controversial of the three that I presented, but I hope you'll listen to reason on it. And I'm going to start out by telling you that my son turns 18 next month, and I encountered this situation again through personal experience. There is a section that's not addressed by this bill, and I'm hoping that somebody here who hears what the situation is can come up with an idea how to fix it, because I wasn't by the deadline of being able to submit bills to address that portion. But we'll start with that because it's peripheral to how this bill came about. It gives background, and it shows another issue that does need fixing if somebody can come up with an amendment they can put on another bill. Knowing that the courts were backed up following COVID, my ex-wife and myself said, well, you know, William's turning 18 in March, and he graduates in June, and so we should probably file a joint motion with the court to change the child support based on him turning 18 and graduating. And so we did. And it was good that we did, because I found out, I had assumed when he turns 18, he would just fall off, and my daughter, who's still on support, would get her support, and his would be changed. The support amount would be changed for the fact that he turned 18 and graduated. That is not the case. If you have more than one child, child support continues garnishing your wages at the same amount once that child turns 18 and graduates, and the remaining child or children continue getting the same amount of child support, unless you know enough to go in and say, hey, one of them is no longer on child support. He's 18 now, so we need to change the amount. So in essence, what I was paying for two children would have continued for one child, unless I knew enough to put the motion in. So that's the part that isn't fixed by this, that there is no automatic way to change the child support amount when a child turns 18 and graduates. Now, the part that is covered by this is an egregious situation, and I have turned over to the chair my own uniform support order final from the court. I have not distributed it to the committee because it does have private information in it. However, he has the ability to read it and to attest to what was written in it. The way the law is written, it says that the child must turn 18 or graduate, whichever happens last. So, my child having ADHD and ODD, and we've been battling with multiple IEPs throughout his schooling and urging him and helping him get to the point where he's about to graduate, may fall a few credits short. And we're doing everything we can to make sure he graduates with his class, because he has told us if he doesn't graduate with his class, he's not going to finish. He won't go back another year, and he won't get his GED. He's just going to go into the trades. And on my uniform support order, the marital master in the court wrote that because the law says that he must turn 18 or graduate, whichever happens last, that this uniform support order changing the amount of child support is null and void if he doesn't graduate. And that until he gets his graduation, I will continue paying child support to him, even if he's 24, even if he's 32. Turning 18 does not end the child support. The way it's written now, he must graduate. And it's written right in there to emphasize the fact that he must graduate. Now, if this had said whichever happens first, we wouldn't have this problem because he turns 18 in March, graduates in June. He would be out of the system for turning 18. But then you might have the situation where you have a gifted child who graduates at 16, and then you're depriving child support for 2 years until they turn 18 because they graduated first. So we don't want to do that. Instead, my bill here will just strike the graduation component. If a child decides to quit school on their own, you shouldn't be, or doesn't go back to finish school, you shouldn't be on the hook while they're a young adult. There's nothing in the law that says that the child would, and nothing in that uniform support order that says after he turns 18, he even has to still live with my ex, but I still have to send her child support. So that's the issue we're with now. This is simply striking from here, complete his or her high school education so that turning 18, getting married, becoming a member of the armed services, or gets an emancipation through the court are reasons for termination, but graduation is not. And that's what I hope you will consider, the fact that and if anybody wants to say this doesn't happen, it's just it would never be done that way. I'll now allow the chair to tell you about my court order.
Having read privately the court order, I will attest that what the representative says is written in this document. Are there any questions for the representative, Representative Raymond?
Thank you, Mr. Chairman, and thank you, Representative Spillane, for once again sharing some of your personal story with us. I appreciate it. And I believe you 100% that that's what your court order says, because I've seen those court orders. Typically, in my experience, those situations where it requires graduation are for our students who have IEPs or some other type of learning disability that requires them to continue school until they're 21. And I believe we might be considering 22 these days. The idea being that these are not children, these are not young adults who are able to live on their own and because they don't have the skills to do so. So our education laws consider them children until they have hit 21 or 22, and thus child support does as well. So my question is, how would this law impact those kids? At 18, are those children, or I guess young adults, now able to get some other type of assistance for their living arrangements?
Thank you for the question. There's another whole section of paragraph in here that deals specifically with children who are disabled or are pulling Medicaid for their disability, and situations when it's under a situation, and I don't have the law and I'm not really familiar with it, but it comes under a heading of situations when child support may be extended beyond the normal time of turning 18. This paragraph was only dealing with the standard automatic termination of child support, which, as I mentioned, isn't so automatic if you have more than one child. You have to actually go back and ask them to change the amount, because otherwise it just keeps going. If I had 5 kids and I was paying $2,000 to $4,000 a month, and all of them turned 18 but one, I'd be paying $4,000, $5,000 a month for one child, unless I knew enough to go back to the court and ask them to change it. But that's not part of this bill, so I won't digress too much before the chairman gavels me out on that one.
So if I were to, I'll pull it up. If I pull up 461 A, it'll be under there.
There should be a section that
specifically for
talks
that.
about reasons why child support may be extended beyond the normal period. And it's some of the reasons were disabled children, those who were pulling Social Security benefits because of a disability, et cetera. And I believe it does mention 21, 22 or something in there.
Thank you for pointing me in the right direction.
Yep.
Representative Grossman.
Thank you, Mr. Chair. Thank you, Representative, for coming before us. So I have a situation. I have an 18-year-old son who has an IEP, who's a senior at Exeter High School. I'm currently not involved in divorce proceedings, but his birthday was February 2nd. So under this, support would end for him.
I didn't know how else to deal with this because we do have a situation where, I mean, I toyed with ideas of saying the June of the graduating of the June of the year that he turns 18. You know, but you're always going to have somebody that's on an outlying situation. And like I said, my son turns 18 in March, graduates in June. If this was the law at the time, right now, yes, the child support would technically end in March, but I have an understanding with my ex that I'm continuing to June anyway when he graduates, so it wouldn't have affected us with our own situation because that's our own personal agreement.
But
Follow up.
it could affect others.
There will always be someone on the outliers, yes.
And then I guess I would need some clarification in terms of I've had families come to me that have children with disabilities and their child support ends at 18 very specifically, that there is no longer support after that 18. So I'm curious about the law and how it handles children with disabilities. So in my case, my son will be part of Exeter School District until he's 22. That's the new law change. But if we were in divorce,
So
I'm confused.
the section about when it can extend that the other representative was asking me about would cover that situation.
And that's an
because-
agreement between the two
No,
parties, right?
there's actually a section of law that says reasons why there may be a determination by the court to continue child support beyond 18. And under there are many reasons or things listed that could be a reason why the court could decide that you are still obligated to continue your child support beyond the time of 18. And that's actually written in there in a section of when can the court consider going longer.
Representative Nelson, I think you may have some language that helps here.
Thank you, Mr. Chairman, and thank you for taking my question. I do, and I am open to other people suggesting maybe better wording. I completely get where you're coming from, Representative. I do have some pause about turning the age of 18, period, because there are a lot of kids who are born in January, February, March, April, May. And from experience in my own family, there's a child who just turned 18 in January and will be graduating in June. And that support order is keeping him in his home, you know, where the money is very tight. So I was thinking that might be the case with other people. I don't necessarily think it's maybe an outlier situation. So would you be amenable to something like saying, and provided they are attending high school?
I looked at a lot of different options, and I'm certainly the whole reason it's in front of the committee is so the committee can discuss where there may be some shortcomings and what we can do to go around those, but still solve the problem of a perfectly able-bodied child who decides to quit school at 17, turning 18, and still collecting child support because they don't want to graduate.
Yes.
So I'm open to all of the ideas that come before the committee. I feel like it's a situation that, you know, needs to be fixed. Certainly, to see it written in a court order against myself to say, wait a minute, you know, and neither one of us could believe that they were saying this. And we came to our own agreement that if I have to keep paying it, they'll just pay it back to me. But that's just kind of annoying. And for how long? Because there's nothing in there that ever says it has to cut off for him the way that it's written.
Thank you. Appreciate it.
Chair recognizes Representative Ball for a question.
Thank you for recognizing me, Chairman. So if it were to say something like July 1st of the child's 18th birthday, the year of the
Of
child's
the year of the child.
18th birthday, if attending high school or if attending an approved school, like a high school or a trade school or something, that they would at least finish out that year.
Keep in mind, we have a lot of homeschooled kids too at this point. I would be wary of any language that says they must be attending a school. They could be doing the senior year of their homeschooling and
or
then,
continuing their education,
yeah.
something like that, but somehow end it so that at least they get through that year of their 18th year to the end.
Sure, as
of
long as it's
July.
clear enough to not also bring in trade schools that they want to go to next, or because we're not trying to force parents. That's part of the other agreement that they make. Am I going to cover college? Am I going to cover these things? And that's agreements that are made in the final divorce decree. And we don't want to put something in place that makes it untenable for them to come to an agreement by forcing a situation where now somebody's being forced to pay for the schooling going beyond what was agreed to already. Obviously, we're trying to constrain this to the high school period.
Right, that's why I was trying to
yeah,
say within that
yeah.
18th, at least within the 18th year.
And the
then we would-
acquisition of a
yeah.
GED, would terminate that too, I think. But the way it's written, it says it doesn't say that. It just says that if he doesn't get enough credits to graduate, I continue until he does. Now, doesn't say till he takes his GED. Says till he gets the credits. If he quits school, he's never going to get those credits. So there's a problem there.
Mm-hmm.
And it's basically comes down to the way this is written to say whichever is later, and that whichever is later puts you in this bind of it may never come. Later may never come. So we need to have a later that is a thing that's going to happen at some point, so that it will always be an end to it.
Thank you.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here and testifying. So there's something, my kids get Social Security because their father died. So there's something, they have some wording, and I can't find it right now, but I'd be willing to talk to you and look at that, because they have some kind of wording where it doesn't continue on forever. It happens either when they turn 18, or my daughter was 18 in November. Hers goes when she turns 18. She's only 16, but then it doesn't end until she graduates. So she gets to graduate, but they have a pretty tight provision. So I'd be willing to look at my paperwork at home and then talk to you about that.
If there's model
want
language
to.
somewhere that's being used by the Social Security Department already to make sure that they end their benefits at a certain time, it's worth looking into.
Yeah. So if you would be willing, I'd love to talk to you about that.
Any other questions for the representative? Seeing none, thank you so much.
Thank you.
And the chair recognizes Keith Koenig from Waypoint, who says he will be speaking against the bill for 3 minutes.
Mr. Chairman, members of the committee, for the record, my name is Keith Kinning. I'm the advocacy director at Waypoint. We sit in opposition to this bill. After listening to the sponsor, there sounds like there are a lot of problems that need to be solved, but I don't think this bill answers those. And taking out the language taking out the language and only leaving when the person turns 18 just seems to me that it's a one size fits all to try to make kids, and kids are not that way. Let me give you some what ifs. What ifs, and I can share something personal. What if you have a younger brother who's only 4 years younger than you, but the parents have decided that they need to hold him back a year because they think it would do him better to go in a year later. So he graduates 5 years behind me. And then what if your parents, as mine did, got divorced? And so they've made a decision about their child. And my brother entered high school. He entered his senior year as an 18-year-old. He graduated. He holds down a job. He did everything he was supposed to do. But imagine if that support had been cut off as he was going into his senior year. What about my son? Between his junior and he was one semester away from graduating from college. He got a severe concussion. What if that had happened during his junior year or his first semester in high school? Do we cut off child support at that point? Children, we all want to believe that we have expectations with our children. And if anybody has a child, that just doesn't hold true. You have to adapt to what your child needs. And so I'm thinking about 50 other things we could talk about. Depression. I think they're saying now a third of young teenage girls are severely depressed. What if someone has to drop out for a semester because they can't hold it together, but they want to go back and get their degree? Or what about substance abuse? Or what about just a medical injury? So I hear the sponsor. I think he's trying to solve a problem, but the way this bill is written, this one size fits all is not the answer. And it's going to leave a lot of kids out there having to choose between getting their education, which I think we all want, don't we? Don't we want them in this high tech world to get their education? Or they're going to have to be forced. They may not be able to continue their education and go to school. So I would ask the committee, if you're going to do something like this, I think we need to figure out, 22 and the right language, but not just eliminate this, because it just seems to me it's going to put a lot of kids in a really bad situation. So thank you for your time, and I'm happy to answer any questions.
Any questions? Representative Raymond.
Thank you, Mr. Chairman, and thank you so much for being here on behalf of Waypoint. Does Waypoint still run foster homes?
We do.
And so my question then is, what effect would you see this having on kids in foster care? Because I know we have like 1,000 kids in foster care right now.
So
across the state.
thank you for your question. We run something called an ISO program. It's the intensive service option. And I will not share with you some of the horrible things these children have been through at the hands of their parents. It is beyond belief. But a lot of those kids literally need a team of people, 6 to 10 people working with them through a weekly basis to stabilize them and move them forward. If you had child support in this situation, there are a lot of those kids that don't make it through high school by the time they're 18. In the perfect world, every child fits every perfect timing of the school and everything that goes forward. I have not found that perfect world. And it just seems to me this bill is, like I said, a one size fits all, trying to solve a problem that we need. There needs to be more thought with this. And it's much more of an intricate situation that I think the bill represents right now. I hope that answered your question.
Any further questions? Thank you so much.
Thank you.
Chair recognizes Representative Deborah D. Simone.
Thank you, Mr. Chairman, and thank you to the committee. I'm Deborah D. Simone. I represent Rockingham 14 Atkinson. I just wanted to say a few things concerning this bill. I am in support of the bill, and with all due respect to Waypoint and all the amazing work that they do for the children of our state, I think that we need to take into consideration the fact that they are correct. When a child suffers from the issue of divorce, sometimes those children, ages 16 and 17, just don't want anything more to do with their families, so they apply for, and in some cases are granted, emancipation. Now, if this child is granted emancipation, at that point, there are a multitude of ways that they can support themselves. And if that's their choice, and they do a good job of it, and most of them do, the law specifically states at 18 years old, that comes to an end. So if emancipation can come to an end at 18, when they become a legal adult, why would a parent have to pay child support if, according to statistical information, a child decides to drop out of school? Now, I don't advocate that. I think that that's probably one area where I would use the S word, meaning stupid. And I mean no disrespect, but I think that every child should finish school. It just is. However, according to statistics in New Hampshire, 2.7% of the kids in New Hampshire didn't even finish the 9th grade. Isn't that sad? 6.2% will not graduate high school. So if you're an 18-year-old and you choose not to finish high school, it's a very poor choice. However, doesn't it make it easier for that child to do that while that child is still being supported by the parents, instead of pointing that child in the direction of becoming more responsible? And if they choose to make the bad choice of quitting school, get a job. And maybe that will force them to go back to school and get their diploma or their GED. I don't think that parents need to be on the hook to support their children who are not going to make good choices once they turn 18. Thank you.
Any questions for the representative? Seeing none, thank you. The chair recognizes Lisa Dekatowski and Matthew Hayes from the Bureau of Child Support Services.
Thank you, Mr. Chairman and members of the House Children and Family Law Committee. On behalf of the state of New Hampshire Department of Health and Human Services and Bureau of Child Support Services, I thank you for giving us the opportunity to briefly speak on HB 583. I just want to say at the outset that obviously the Bureau's position is that child support is a vital resource for New Hampshire families. And I can say that in many cases that we've seen, dependents, generally a lot of dependents do turn 18 prior to graduating high school. And that as such, this bill could result in less child support being collected for those families. And that would result in some hardships for families, and it could result in the increased need to turn to public assistance to help those families through that last time period. In addition, this bill would have some impacts on our program. However, I think it's up to this committee and the legislature to make a policy decision on how they best see fit to draft it. And it's our hope that if there's changes, they can make changes that are advantageous to families in the state of New Hampshire. I'm happy to take some questions as well, unless a director has any input.
Seeing none, thank you so much.
Thank you.
Chair recognizes Attorney Richard Head from the Judicial Branch.
Morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I have a very small technical request in terms of this bill, which is a change to the effective date from 60 days to January 1. The reason for that is RSA 14:9 talks about when effective dates should be set. And it says each law affecting judicial practice and procedure shall take effect January 1 following passage. Because we have standing orders and forms that incorporate the current language of this bill, and we get a number of form changes and various document changes that we have to do in the course of or following a legislative session. The law provides for a January 1 effective date. We do not have a position on the policy of the bill, only a technical request. I've spoken to Representative Spillane. He actually brought it up to my attention before the hearing. And asked me about that. So I appreciate his pointing that out.
Any questions? Seeing none, thank you. And with this, I close the hearing on House Bill 583. Representative Spillane, looks like you got some people who want to tweak and work and fix. And I would check, please, line 10. I wonder if the age is now 22 from the work I do with the DD community. I wonder if 22 is the correct age. So while you're tweaking and working and so on, have some fun. You got a lot of people here who want to help you. I've given the committee school vacation week off, so they'll be around. With this, I open the hearing on House Resolution HR 15. 14. Okay, we will make that change to the pink card. Say again. Not my problem. Have fun. Find out. 14, yes, indeed, a resolution to urge the investigation of due process in family court cases. The chair recognizes the prime sponsor, the Honorable J.D. Bernardi.
Thank you, Chairman Pearson and the Child and Family Law Committee. My name is J.D. Bernardi. I represent Rockingham 36, which is Hampton Falls, Kensington, Southampton, Newton, and Plastow. I rise today to introduce and support H.R. 14. Now, passage of this resolution would establish a committee of either the members of this committee or a select committee to be appointed by the Speaker. And its purpose is to investigate the allegations of denial of due process of participants in the current court family division. Note, this is a House resolution for a purpose, because the other body, i.e., what we call the Senate, despite numerous bills that have been passed by the House attempting to address various due process issues, has repeatedly failed to move them forward. Further, this resolution does not require gubernatorial approval. The authorized committee would have the power to subpoena and compel attendance of state officers, including jurists and DCYF employees. One may also consider including the ability to issue a transport order to get those in jail to testify. The kinds of due process violations that could be investigated, and you have heard about already in earlier bills, is the waiver and suspension of court rules. Rule 1.2 permits the court to waive any rule in the family court that's not prohibited by law. Rule 2.2 permits the court to waive rules of evidence because they are not deemed to apply. You'll hear again legitimate testimony of where the existence or falsity of abusive relationships was denied, when that testimony could have been determinative of a fair and just order. At a minimum, all waivers should be explained for the appellate record. The investigation could also assess the issue of court recordings, which are inaccurate because they have been electronically stopped in order to exclude offensive or inappropriate judicial comments. And hence, the recordings result in inaccurate or incomplete court transcripts that are the basis of legal appeal. The Commission can investigate the repeated failure of the court to follow statutory timelines, which adversely impacts children and parents. There appears from testimony offered a financial benefit to the court from protracted cases with endless streams of hearings without final resolution. It should be noted that although the district and probate courts have limits on the income of judges, the family division has no similar limit. I refer you to RSA 491A. The complex and protracted cases also appear to be a repeated combination of the same judge or master, guardian ad litem, and therapist. A legitimate question is, are there financial ties to contractors and associates that are influencing decisions? Numerous problems have been reported with the Bureau of Child Support Services in the proper and uniform accounting of child support payments. Maladministration here could be devastating to parents relying on proper management of court-ordered payments. This is also an area for legitimate investigation. Finally, you've heard of too many cases where it appears the reunification standard has been inappropriately applied. The denial of the existence of abusive relationships as a rationale for not reconciling has not been appropriately considered. Too often, a parent feels that the loss of their child may be the consequence of noncompliance with the court. The family court has unlimited equity jurisdiction. Without the same kind of constraints and regulations and laws that govern the district court and the probate court. Essentially, the testimony that you're going to hear following me concerns a myriad of due process failures, and because of arbitrary judicial discretion that is often unsubstantiated and without justification. The record does not justify the decisions made. They cry out for an investigation to determine their veracity and the definition of a plan to remediate any truths revealed. I've distributed, and I think it's going around, there's 4 testimonies of individuals who cannot be here, who have submitted them through the portal for review. And knowing the volume of these things that you're getting, I just wanted to highlight these 4. From the Honorable Dan Itza, who served on this committee for 16 years, and in his last term, 17 through 18, was its vice chair. He makes the point that the laws ultimately should not be causing abuse to our children. It must permit responsible parent or parents to provide for their care and protection. He supports the resolution. Paula Verme, a retired New Hampshire attorney, and I hope I didn't mess up her name too badly, who has focused on child and family law issues, conducted an audit of abuses in the Rockingham County system in 2012. She supports the resolution and strongly recommends that the Judicial Guide to Child Safety and Custody Cases by the National Council of Juvenile and Family Court Judges be a starting point. Shauna Brown, another retired New Hampshire attorney, makes the case that perjury is a major problem in family court cases. And finally, Alice Giordano, a veteran journalist with the Boston Globe, the AP, the New York Times, and now the Epoch Times. She has personal involvement in the system herself. I want to read one quote. In my 30 years as an investigative journalist, I've never come across government corruption so egregious as the corruption in the family court system, with New Hampshire leading the pack. I strongly commend you to read her entire testimony. And I also received the testimony of a young person who was impacted by the court system, and I only have one copy, so I'm going to read this, a portion of this for you, and then hand it to you. I cannot be here today because of the trauma I suffered as a result of written orders that were full of unsubstantiated and parroted disdain for my mother. Orders that ultimately would lead to a new series of trauma and harm. You see, I was diagnosed with severe complex PTSD at 18 after returning from being kidnapped. The diagnosis is a result of years of emotional abuse, gaslighting, medical neglect, and more at the hands of my father. At 25, I continue to place my mental health as a priority and am in productive form of therapy. It was decided that testifying and hearing other similar stories could cause me severe setbacks. This abuse was preventable had the court accepted my parents' final divorce decree and family history evidence upon entering the family court system. My experience is only one of thousands of children being put through the harm and significant trauma at a time in their lives when they should be flourishing, learning, and feeling safe. As a child, I had a caring parent who protected us from abuse and harm. Our respect is rooted in how our mother gave great love and respect to us, always showing us the world and encouraging our growth. We kids were safe and secure with her and with one another. The court stripped that right from us, the safety from us, and by doing, I believe, perpetuated future harm that we are all going to suffer. Orders rooted in New Hampshire Rule 2.2. This is the evidence rules do not apply. I ask your consideration through this process and any process hereafter to bring your thoughts back to these questions. Does H.R. 15 follow a just and unbiased path that could result in healthy outcomes for all, children included? Does this resolution contribute to healthy public policy preventing decision-making authorities from benefiting from extended suffering of others? If the answer to these questions is yes, then it is, from my experience and moral opinion, H.R. 14 could be the beginning to rebuild justice for all. Please take my story and apply it to all the thousands of voiceless children that have been abused and put in danger because of failures in due process and rules of evidence. Think about New Hampshire's children that you will not hear today with stories like mine. Prevention over everything else. So the bottom line is this resolution offers you an opportunity to investigate the truth of these kinds of circumstances. Are they really happening or are they not? It's a simple question, and the committee, upon investigation, can make that decision, and if they find there are abuses, there are problems, can propose legitimate fixes. If they find there aren't any, then there's nothing more to do. Willing to answer any questions.
Any questions for the representative? Seeing none, thank you so much. In cases like this, where the person presenting the bill makes a very thorough presentation, the chair chooses to take one person, in effect, to be the chief rebuttal. After that, we will go into the 3-minute rule, and your testimonies will be limited accordingly. It would not be fair, in my opinion, to go to that 3-minute rule right now. So the chair would ask the Honorable Bob Lynn, you have as much time, sir, as you need.
Thank you, Mr. Chair and members of the committee. I signed the card saying I oppose this bill, and I guess what I would really say, I don't, far be it from me to say that the legislature, doesn't have the authority, or that it wouldn't be appropriate in some circumstances to investigate another branch of government. I don't say that at all. But I am really concerned, and I guess what I'd like to do is just raise several of the things that concern me about this resolution, to hope that you'll think about it and then come to what you think is an appropriate determination on this bill. The first thing I'm concerned about is I can't help thinking that this is deja vu all over again, so to speak, because if I recall, weren't there similar allegations made back around in the 2010-2012 time period, where there was a committee for redress of grievances formed, and a number of the allegations were that the judicial branch family division the judges were corrupt and biased, and they made decisions without a proper basis. And as I understand it, when all was said and done, and people actually, for example, looked at the transcript or the tape of something where somebody said, "Oh, the judge just made this decision. There was absolutely no reason for it." Well, when you go and look at the tape of what happened, it turns out there actually was a reason for what the judge did. And so I guess what I'm saying is I'm really skeptical about what you're likely to find. Now, that doesn't mean that, can I say absolutely that there's no basis for any of this stuff? No, I can't say that, but I can say that I'm skeptical. And the other thing that I can say is I think it's really important that you understand that the information that is often being provided to you, in fact, I think probably exclusively in these allegations, is you're hearing complaints that either directly or indirectly, because somebody has complained to their legislator, of people who are litigants and are one side of the story. And most of the time, they are people who have lost in the litigation. So they've come and told their legislator, this terrible thing happened to me. The judge was biased. He or she waived the rules when they shouldn't have, and all this. You've never heard from the other side of the story. You've never heard the litigants on the other side, what they have to say. And of course, they're not going to come in. They've prevailed in that litigation. They have no reason to come in and talk to you. And so I guess what I'm saying is it's really important, it seems to me, that if, for example, you decide that you want to, or the House decides that it wants to conduct some kind of an investigation, I would think that the first thing that committee should do would be to go read the tapes, listen to the tapes, or even order the transcript of the particular cases where somebody is complaining, and see both sides of the story, what each litigant presented to the court, what the judge said as to what he or she was the basis for their ruling. And I suspect that you're going to find a completely different story. And I'll just give you a couple of examples. I've heard, not from the representative who testified before me, but I've heard in the past from representatives tell me stories of things that judges did that, I spent 26 years in the court system. I think I have a pretty good idea of sort of how things operate. And when I would hear that story, I would say to the person, well, did you talk to the person on the other side? No. Did you look at the tape of the thing? No. And in many of those circumstances, it was really clear to me that, if I imagine the worst judge I could possibly think of in New Hampshire, and I assumed that judge had spent the night before drinking and was intoxicated, he or she would never have done what was alleged if the story was only what the representative had been told, which led me to believe there is another side of the story that the complainant didn't bother to tell the representative who brought that forward. So these are some of the concerns I had. Let me give you another example of something I think is really important. If you look at the record of the Judicial Conduct Committee, that's the committee that investigates judges for misconduct, you will find that the overwhelming majority of the complaints filed against judges are in family court cases, because those are the ones that generate the most emotion and hard feelings and, angst among the litigants. That's the overwhelming majority of them. And if you also, if were to look at that, you'd find that the overwhelming majority of those cases are dismissed, finding no judicial misconduct, because what the complaint is about is a litigant who lost has made a complaint that the judge was biased, or the judge, didn't see things the way that the litigant does. And in fact, that's not misconduct. I mean, the thing that I think some people, unfortunately, have a real difficult time accepting, and I use just a very basic example. If I'm the judge and the question is, did one of you drive through a red light or not? And you say the light was green when I drove through it, and another witness says the light was red when you drove through it, the judge has got to decide that. He or she has got to decide what is the truth. And if the judge decides that, contrary to what you said, the light was red, you may not be very happy about that at all. But if you go to your legislator and say, the light was clearly green, but the judge found it was red and there was no evidence of that. Well, they conveniently left out of that scenario is the fact that another witness testified that the light was red. That, unfortunately, as I think is what is likely happening here. The last point I would make, and I think this is particularly important, is to the extent that this resolution purports to suggest that this committee would have subpoena power and that it would subpoena judges, I think you're going to run into a real problem there, because judges cannot, if you're talking about any case that's still pending, and some of these cases go on for years and years and years, the judge will not be able to respond to inquiries. The judge cannot answer your questions. It would be a violation of the Code of Judicial Conduct for him or her to do so. The rule, even with cases that have been, that are sort of over, I mean, in family law cases, even when a case has been gone to the Supreme Court and has been, reviewed by the Supreme Court, that often is not the end of the matter. There may be further proceedings. And so the case may not, even though it may look like it's over, it may not be over. And so, again, that would present a real problem with judges being able to testify in those cases. I think, frankly, they would say that they could not. I mean, if I were a judge in that position, that's what I would say. And I think you don't want to end up in a situation of some kind of separation of powers, constitutional issue. There's just no reason to do that. So I guess what I want to sort of express generally about this is I'm very skeptical that there's really a basis for an investigation. And the idea that judges are corrupt and that they have been, that they're somehow on the take to prolong cases so that they can somehow get money out of it. I'm really, really skeptical about that. But I hate, I don't want to be the one to say, oh, no, it couldn't possibly happen. Could it possibly happen? I suppose. What I would suggest, though, is before the legislature spends a lot of money on this, if you're going to do anything, I would suggest as a first step to say, look, all right, let's find a few of the cases that we think raise the most concern for you, and have somebody go read the transcript of those cases. Order the transcript, read the transcript, or listen to the tape, and then make an initial assessment. Okay, we've now heard word for word what happened in those proceedings. What do we think? Do we think there's a basis to take some further step? I suspect you're going to find in virtually all of the cases that there isn't any reason to do that. But if it turns out that there is, then by all means, you should go further. With that, Mr. Chairman, I'm happy to take any questions, and I thank you for giving me your time.
Representative McMahon.
Thank you, Mr. Chairman. Representative Lynn, specific to your last comment you made, does line 5 and 6 speak directly, 5, 6, and 7 of the bill speak directly to that recommendation?
Yeah, I mean, it's worded pretty broadly, but so I don't know that it sort of specifically says that that you should do it in the following manner by sort of looking at the transcript first. But I think that would probably, to me, that would be the way that would make the most sense and be sort of the most economic, the most productive of your, finding out if there's a basis to look at, to see if there's some if there really is a basis to go further. That's what I would say.
Follow up.
To stipulate to what you just stated, then, should there be further detail in the narrative?
In certain terms of the narrative of the resolution, yeah. In other words, that's really a very good idea. You might want to say, for example, you might want to say that we will, the legislature will, select from some cases from those cases where it appears that they're, the allegations are particularly specific of something in particular being wrong, and we will assign people to go and read the transcript of those cases and see what, if in fact from doing that you have a base that you come away saying, well, we've looked at the transcript now, we've sort of seen everything that appeared to happen before the judge, and we still have a question. And if you do, then by all means, that I'm not suggesting, I as I said at the very beginning, the last thing I want to say is that the judicial branch is like absolutely beyond touch. It shouldn't be untouchable. You should have the right to look at it. I'm just sort of saying I'm skeptical about the allegations, and you should, I guess, approach it in a sober manner is the way I'd put it.
Thank you.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you to the representative for taking my question. Do you offhand have any idea how many justices have been removed from the bench in the last 5 years?
The last 5 years. Well, I believe that there's two that I know of, and one resigned. One marital master, I think, resigned under under circumstances that at least raised a question. Yes.
Follow up, please.
Follow up.
Thank you, Mr. Chair. So is it your opinion, sir, that the Judicial Conduct Committee is working their best to do their job?
I think they are. I think they do a very good job. Sometimes does that mean that they have sort of advanced knowledge that somebody has done something wrong? No, they typically don't. But I think when they get information that suggests that there's a problem with a judge, they take action. That's been my experience.
Thank you, sir.
Representative Bickford.
Thank you, Mr. Chairman. Thank you, Judge Lynn. Do the power to subpoena, is that a problem here or not?
Well, I think in terms the subpoena itself, probably not. I think if you're the problem would be if somebody says to a judge, I want you to tell me why you did what you did. That would be the problem, because the judge is not allowed to do that.
All right, follow up.
Follow up.
Thank you, Mr. Chair. I certainly would welcome your input for an amendment for something like this, because I think it goes beyond the redress issue that was going on before. Since I've been back, I've noticed a disconnect with the courts and understanding of what they do. I can speak for myself. There's something coming up, and we've been told not to do it. A paid person from the courts has told us, don't do it. Then we've had other people say, come in and do it. But I go like, I know something, I think I need more information. I would really welcome having some kind of a study to do. I was creator of the Family Law Task Force. I don't know if you recall that or not.
I do.
And we came up with incredible things because of the information we shared amongst the judicial members in child support and other people. The same thing with child support. I was on two of those.
Representative, to the point, and then stop, please.
We went around. Well, what I'm doing is I'm saying I would welcome some positive input, because I think we need that I think we need something to study, to look at, and understand the system.
Okay, well, sure, no, I mean, I would be happy to work with the committee or any, or you or any members of the committee to try to, draft some language that, along the lines of what I said, if that makes sense.
Yes,
Good. Thank you, Chief Justice. Thank you for coming up and testifying today. Appreciate that.
Thank you very much. Thank you.
Now we go into the 3-minute rule, and 3 minutes means 180 seconds, and I can shut your mic off. And the reason for that is there's a lot of cards here, and I will say it is 3 minutes. Be careful about, always be careful about slander and libel. And make your point, and make your point to this resolution. Give us a reason why you think this resolution is good or this resolution is not. And again, 3 minutes. The chair recognizes Rochelle Pouget. Did I have that right? Turn your microphone on, please. There you go. Now the clock starts.
Okay, my name is Rochelle Pouget, and I support the HR 14. I would like you to know that my case has been going on for 10 years, and it is a case that involves extensive amount of abuse, financial abuse, emotional abuse, physical abuse, and the cover-up of those abuses by the New Boston Police Department, a guardian ad litem, and multiple judges in the family court system. To begin with, I'd like to tell you who some of the judges were in my case. And the only reason I'm here and able to speak to you today is because my ex-husband is now deceased, and I've had my daughter back since she was 11, full-time. I'm also a teacher who had to go out on medical disability for a permanent medical disability for PTSD, anxiety, depression, and other health-related issues because of this. My first judge was Paul Moore. He has been disbarred. My second judge was Philip Cross. He's been impeached but allowed to return as a marital master and a referee. My third judge was Julie Introcaso, who had to resign after whiteout felonies. My fourth judge was Bruce Delbra, who also resigned after all of his court cases were taken away by the Supreme Court. The cover-up of police abuse, guardian ad litem abuse, attorney abuse, medical neglect, child molestation, which my daughter was molested, and judicial abuse has gone on for too long. The John Coughlin County Attorney won't investigate real estate fraud that could possibly involve his wife, and now our home has been taken away from us due to this fraud. There have been tampering with lobby videos that the Department of Justice refuses to have forensically examined, even though I've had them forensically examined and paid $3,000. And they have been tampered with. They have been edited and muted while the video is still running to obstruct justice. The guardian ad litem in my case routinely does not investigate cases, blocks you from getting a copy of her GAL file during investigations, extends GAL fees, needlessly extends those fees, and needlessly extends GAL cases so that she can profit from this. She removes parental rights, like she did with mine, to avoid having hearings about the termination of the guardian ad litem, which was coming up in my case. I had a 4-day hearing coming up, but they went in and took my parental rights after I reported an accurate second DCYF molestation incident involving my daughter that was verified after my parental rights were taken away, after I was forced into mediation under extreme duress.
You have 15 seconds.
And after, I'm sorry, I don't mean to cuss. Sorry. Anyway, nothing gets investigated. John Coughlin covers things up, and it goes all the way. Oh, there's whiteout all over my court orders, and the Department of Justice won't investigate it.
Thank you so much.
Completely
The chair now recognizes Matthew Routhier. And once again, 3 minutes.
Good morning, chair members. Matthew Routhier,
I'm here in support of this bill. As Representative Lynn pointed out, the majority of the complaints against judges is in the family court. I just did a quick little research from 2017 to 2021. And during that time period, from 2017, the complaints filed for family court judges was about 34% of the total complaints. And as of 2021, that is up to 70% of the complaints. I feel that this resolution is a necessity because due process stands for fair procedures. And part of that is an unbiased tribunal, the right to present evidence and call witnesses, and a decision based on evidence, as well as the requirement of the tribunal for written finding of facts and rulings of law. That seems to not be the case in the majority of family court cases. If you were to, I venture, if you were to look at the number of appeals that are before the Supreme Court, they again would be based on the fact that judges have not fulfilled that requirement for finding of facts and rulings of law. I feel that in my certain case, when my case started, I had to file a motion for emergency order to have time with my daughter. That ended up in a hearing, and then 2 months later, we were in another hearing for temporary orders. As part of those temporary orders, I did not have any increase in time with my daughter, with no findings. There was no parenting plan provided, and these are the type of things that people suffer when there is no accountability. You know, I believe that this country, again, was built on checks and balances. It's obvious that you folks have the ability to, you know, do that with this House resolution, and I feel that that is a necessary thing based on the testimony you hear on a regular basis, as well as the number of accounts and appeals that are filed in regarding the family court.
Thank you, sir, and under time and on point. Any questions? Seeing none, thank you. And the chair recognizes Representative J.R. Hole.
Thank you, Chairman, members of the committee. Representative Hole, representing the towns of Dunbarton, Hooksett, Allenstown, and Epsom, here to testify in favor of the bill. And I want to start off real quickly. There is something called confirmation bias. You see what you want to see, right? And for those who think the judicial system is broken, they'll see it that way. For those who think it works, they'll see it that way. And I think we should take all testimony, right, in light of that. Your task as a committee is to look where are the facts. For the record, I'm going to talk about my personal case. We won the case. I think the representative from Wyndham made the case for passing this House resolution because he talks about we should go look at transcripts. I want to talk about transcripts. I want to talk about things you guys can't see because of the confidentiality nature of many of these cases. DCYF cases are confidential in nature, and the transcripts can't just be read by anybody. At risk, I'm willing to read some of the transcripts from my case because I think it's important. And I will summarize with the outcome at the adjudicatory hearing. During the hearing, the overwhelming credible evidence demonstrated that this statement, meaning that I was neglecting my children, had no medical foundation. The credible evidence also reflected that the parents had not neglected one of my children, redacted, in any way, and was certainly not in a manner alleged by DCYF. That was the final outcome. I'm going to start back at the beginning, why the process is broken. In the first order after the ex parte order, an order that I was not present because it was an ex parte order to actually present any evidence, there was an initial hearing. Father agrees to, wrong line. The scheduling of said hearing shall account for the availability of the father's medical witnesses, all of whom shall be able to testify telephonically. That is the judge's order at the first hearing. That is December 16th. Understand this started December 8th. Fast forward to January 21st, we have a status hearing. Okay. I want to read yet another line. Each side will have 1.5 hours to present the case, including cross-examination. The case will be scheduled for 3 hours at the preliminary hearing, which will proceed by offers of proof and cross-examination of the offered witnesses. Okay, I'm supposed to allowed to have my witnesses. Guess what? We get to the hearing where this takes place, and the judge makes a decision on page 83 in this that basically says, I've made up my mind. One of my attorneys, the attorney for my son, objects. And I want to quote his objection because it's so clear that there was no evidence presented from our side during the preliminary hearing because he did not allow the medical doctor, the emergency room doctor I was paying to sit in the hallway at the Concord Court, a chance to testify over a 3-hour window, although his first order said he could be allowed to testify telephonically. I have a problem with that. The system is broken.
15 seconds.
I would encourage you to pass this bill. You never find a problem if you don't look for it. There is clearly something that is aggravating a bunch of families. At least be willing to look under the cover of what's going on. With that, I'll close my testimony.
Thank you, Representative. Any questions for the representative? Seeing none, thank you, sir. Ed Bryans is called up next. Mr. Bryans, welcome.
Hello, representatives. My name is Ed Bryans. I've been coming up here for almost a decade. Frankly, 10 years ago, went through a family court matter myself. I stand with this bill. I believe there needs to be some attention paid to what's going on in the family courts. I see it as a few things. I believe the judicial discretion needs to be tightened. The low level of evidence needed in family court matters. I don't know if we're at a clear and convincing or preponderance level, but there needs to be a level of evidence because in my experience, it's based on hearsay. In my situation, we had an ex parte motion filed basically claiming that I was a flight risk. My daughter was pulled from me on her birthday with my last words to her being cake, friends, and presents. The claim was made that I was a flight risk. 22 months later in my court hearing, after 3 administrative continuances, there was a Facebook message to my father who was diagnosed with stage 4 cancer. I had told him, Dad, I'd love to come see you. I'd love for you to meet your grandchild. That made me a flight risk. At the point where I did get my day in court, the guardian ad litem was completely against me. Her recommendations to the court were that I have 1 day a year with my daughter on Father's Day, and it would alternate on Christmas, on even years. The attorney for my ex had offered me every other weekend with my daughter and Wednesday dinner visits, which I believe is pretty standard with a lot of court orders. The odd thing is, as I pointed out to them, being a pro se litigant with no legal experience, it seemed a little hypocritical to me that they claim I'm a flight risk and keep my daughter from me for almost 2 years, but yet they're offering me every other weekend. I could be anywhere in the world in 48 hours. My feelings are, at the end of my court case, whenever the guardian ad litem would file for a fee increase, I would respond with a motion saying, Your Honor, deny her fee increase. In fact, charge her for theft of services for the money she's already received that she's not doing anything. At the end of my court case, I walked out with 50-50 custody. The guardian ad litem's fee increases were denied. And for 10 years, I've been co-parenting with my ex-wife. My daughter is the captain of the basketball team. She ran for and was elected school president. She benefits from having both of her loving parents in her life. It shouldn't have taken 2 years to get to that point. And during that time, I can't get that time back. I know later on we have a hearing on a shared parenting bill, but I fully believe that the court system needs to be looked at between the guardian ad litems that have quasi-judicial immunity to where they're immune to any perjury or false swearing. there's other situations with some of the domestic violence coalitions that pick and choose their litigants. Visitation center that I was ordered to go to abused my child. When I went to the police department to report their abuse, the officer that went to investigate, because all the visits are recorded, accidentally deleted the tape. So there's a lot of problems. I sit here today. I benefit in no way from any changes in rules and investigations. My time with my daughter is great. My relationship with my co-parent is great.
10 seconds, sir.
I do teach a co-parenting class once a week. I've been doing that for over a year, teaching people how to love their children more than hate their ex. And I hear the same experiences being repeated over and over.
Thank you so much for coming before us. Any questions? Seeing none, thank you, sir.
Thank you.
Chair recognizes Katrina Heinrich from Exeter. She has written testimony, she says, to, you would give it to Representative Bickford and pass it around. And, you know, rather than saying 15 seconds, I'll just hold up a card. That means 15 seconds. I think that's a little nicer.
I have to be looking at you, though.
Starting now.
Hello, I'm Katrina Heinrich with over, a decade in court. I'm for House Resolution 14. Thank you to all your members for your time on this, because this is a serious situation. I come before you today to speak about my experience in the New Hampshire Family Court and problems surrounding due process. While applicable, you're not going to hear me talk about the sociology, psychology, criminology, or cultural aspects of the harm. And with respect, I'm going to talk about my experience about the problematic patterns of public policy, ethics, structured abuse, and financial rewards during my case. Divorce decrees are designed to be final, perhaps on occasion a modification. However, 10 years of post-divorce court is not modification, and my children appeared to be the pawns. Tethered to the court through unsubstantiated motions and orders, a theme emerged: no due process. Dependent on rule, New Hampshire Rule 9 or 2.2, and also dependent on RSA 491-A salaries, case protraction, private contractor rules, and failure to enforce statute. The patterns I'm going to talk about, number one, is Rule 2.2. The rules of evidence do not apply. Pattern 2, the money flow emerged. Went from unnecessary GAL billing to unnecessary therapist billing, and established points of weighted case calculations as referred to in RSA 491A. Resources were flowing from meeting our needs to unsubstantiated need for family court services. A hallmark of my case is the pattern of judicial decisions and predictable orders promoting more and more hearings without relief or resolution. The pattern fosters conflict. Orders show no concern for myself or my children or the regard of our basic needs or well-being. Pattern 4, statute and deadlines seemed irrelevant. Written orders would name people without proper service notification. The protracted case methodology allowing perjury over evidence appears to suggest New Hampshire Rule 2.2 is the foundation of legal workarounds weaponizing the court. I would refer you to the document Representative Bernardi gave you by Manchester attorney Shauna Brown that was written for a bar article called The Truth, the Whole Truth, or something like The Truth. In this, she clearly understands the perjury in family court. Pattern 5 encompasses a business model. The court model emphasizes creating a post-divorce issue where there is none and protracting the case. Reason suggests this court model cannot exist alone as independent on Pattern 6, private contractor associations, which would include the GAL, therapists, and firms that do specialize in divorce services. Pattern 7 transcripts that did not align with what actually happened in the court. It is not that the script is necessarily wrong, it's what's missing from it, which is typically aligned to judicial behaviors. Upon transcript review, alterations appear to occur in real time. Recording control and altered transcripts was always a topic. This committee heard testimony about in 2022 and 2023. And I noted, last month we were all in this room, January 17th, 2023, and we were in attendance when we heard Mr. Head testify to convey that judges do not control the recordings. There's no foot pedal control in reference to any equipment, but he mentioned there was a button under the desk. And with respect, I find this is notable because in January 16th, in 2022, at hearings on this very issue, Richard Head gave testimony at approximately 4:48 to 4:49, stating, and I quote, "Some of that has occurred." He further stated, I quote, "The judges are responsible for the recording." He continued explaining that the budget cuts was the reason for court equipment in the control of judges. This year, on January 17, 2023, I spoke about the prolific churning and protraction of cases. I found Mr. Head's testimony notable. Mr. Head explained to all of us that we need to understand that someone in the courtroom for 30-minute hearing has 20 more people behind them. I interpret that this does not address protraction issue, but in fact confirms protraction. And I will conclude with a summary failure, and I totally apologize for this. Ultimately, what you guys do is important, and the patterns of facts and evidence about family court will lead where it leads. And respectfully stating which are the rights the court never upheld for myself and my children.
Thank you for your testimony.
You are welcome.
Chair recognizes Anthony Kinney.
I saw him first. I don't know if you did.
Yes, go ahead, Representative, with a question.
Thank you, Mr. Chairman. Thank you. On the last paragraph of your page, on the last paragraph and the first page, you say pattern for statute and deadlines seem irrelevant. What is the recourse for that problem occurring?
I think you have to enforce it.
What's that?
I think you have to enforce it. You have to enforce statute. Like, for instance, the example I wrote in there so that I could limit this was talking about I would get written orders with people named in it who were never given any kind of service notification as required. They couldn't show up at court. They didn't know about court, but here they are named in these orders. Well, how are they supposed to be there to talk?
Oh,
Do you see what I'm saying? There's the statute wasn't enforced that they have to give proper service.
okay. Thank you.
Okay, now come up. Thank you so much.
Okay.
It's all right.
Good afternoon, Mr. Chairman, representatives. My name is Anthony Kinney. Sorry if I'm a little emotional here. I'm a resident of Middleton, New Hampshire. I'm here today to testify in support of H.R. 14.
You got to get real close.
Real close. Okay. So the little bit of history of my family case. A couple years ago, when the petition first went in, visitation was withheld. I submitted an ex parte motion, which the other side had an attorney and I didn't. And both the judge and the attorney had requested that there was two motions to be denied. That brought us to a temporary hearing where my rights to my son were already starting to be taken away on allegation. And so when I found out there was a conflict of interest with the attorney and the judge, I had asked him to recuse himself. I'm only here today because I waived my due process rights to be heard by a jury, and I withdrew my appeal. I just finished serving 60 days, Carroll County House of Corrections. It was a full sentence. Judge Greenhall sentenced me on a bench trial for allegedly sending a non-threatening text message about parenting my 10-year-old son to his mother. After Judge Greenhall issued an order restraining me from no contact, I was arrested for sending another text message after he recused himself due to conflicts of interest, but they didn't stop him from finding me criminally guilty and sentenced to 60 days, even after the same complaint was denied by a different judge. When I tried to appeal to Superior Court for de novo, the judge ordered me reincarcerated, preventative detention until I was heard by a jury for the same text message. I withdrew my appeal and my right to a jury so I could be released to spend time with my son because he doesn't understand why the court's doing this. If a family court judge doesn't like you, they can lock you up, throw away the key, and if you stand up to them for no other reason than trying to parent or trying to assert your constitutional rights, I urge you, as far as the subpoena goes, I would like to have some of my questions answered. And as far as an investigation, I do disagree with one side prevailing. We shouldn't be in competition for our children.
15 seconds.
And so if anyone has any questions, I'll be happy to answer them. About what happened to my family is by the committee.
Seeing none, thank you so much. Appreciate your testimony. The chair now recognizes Dana Albrecht.
Good afternoon, Mr. Chairman. For the record, my name is Dana Albrecht from Nashua. Many of you have heard me before. I'm going to joke, I'd like several hours, but we don't have several hours. And that's precisely the point of why we need an investigation to look into this more fully. What we do have is countless victims of the circuit court system that's currently presided over by Chief Administrative Judge David King. And all those victims, including myself, deserve a full investigation and some method of redress. To address some of the things the representative from Wyndham said, I would strongly urge you all to look at the handout I sent around. It's only 3 pages. What you've got there is an email from Judge King about the misconduct. And what you've got after that is what the JCC did about it, which was to dismiss it. Even now, the New Hampshire Judicial Branch refuses to release the complete and unredacted deposition of Judge King related to their own internal investigation of that. And again, to address what the representative from Wyndham said about order the transcripts, I think that's a great idea. How do we order the transcript of Judge King's deposition? And that's why the subpoena power of this bill is so important, because in a family law case where there's proven misconduct, shouldn't at least the Children and Family Law Committee or the House Judiciary Committee be able to get the deposition of the Chief Administrative Judge directly relating to that misconduct and see what they think about it? And again, I could do several hours, but I'm going to leave it there. All these victims, including myself, and all this testimony you've heard deserve a full investigation and some method of redress. So please pass this resolution. Thank you.
Thank you. Any questions? Seeing none, again, thank you so much, sir. And the chair calls Gail Drobat.
Good morning. Thank you, Mr. Chairman, members of the committee, for the opportunity to testify before you today. For the record, my name is Gail Drobat. I reside in Amherst, New Hampshire. In full disclosure, I have not myself been in family court. I have advocated for many parents. This is a horrifying system abusing their children. Each judicial officer and officer of the court take an oath to uphold the U.S. Constitution, the New Hampshire Constitution, and the New Hampshire state statute laws, each of which supersedes the rules of the family court. Rule 2.2, application of the New Hampshire Rules of Evidence. The New Hampshire Rules of Evidence do not apply to the actions listed above those rules. That statement supports the court's already predetermined cases of a winner-takes-all custodial parent relegating the other fit parent to an every other weekend visitor. The waiver of these rules and denials of constitutional fundamental liberty protections denies children frequent and continued contact with fit parents with no finding of abuse or neglect. When you turn a very important court, family court, that is supposed to be protecting the rights of children into a business model and deem it a court of equity, you lose sight of what is supposed to be protected, the most vulnerable of our society, the children. The business equity model wastes the financial resources of the parents by way of ordering unnecessary court-involved guardian ad litems, therapists, and any other court-affiliated professional to financially reward their peers, leaving minimal resources to provide and care for the basic needs of their children. The systemic abuse of discretion and denial of due process will have lifelong detrimental consequences for innocent children. Children do not get a do-over. They do not get to rewrite their childhood and the damage caused by a system that is in place to protect them. The denial of due process, judges routinely not reading pleadings, decisional delays, not holding hearings, or producing orders in a timely manner, going into hearings ill-prepared, not recognizing who the moving party is, fabricated orders that are factually not true, made on perjured material misrepresentations. Not holding a hearing for 11 months, not addressing original pleadings, not addressing mental emotional states of children.
15 seconds to wrap it up.
There's a clear systemic abuse of discretion, lack of due process, denial in constitutional rights, Supreme Court protections, and New Hampshire law throughout the New Hampshire Circuit Court Family Division at the expense of innocent children. Removing fit parents from their lives contributes to every societal ill we face today.
Thank you so much for your testimony. If you have handouts, start at the end, and he will distribute them. The chair now recognizes Lori Obadaro. Did I get that right? No, I read better this way. Thank you for coming. Okay, and to show you can multitask, push the button on the mic.
Perfect.
Great.
Okay, Lori
You're good.
Ortolano. I live in Nashua. I've never been involved in family court, so I'm speaking as an outsider, but I'm speaking as an outsider that has some knowledge of what some of my friends and my sister-in-law went through with their encounter in family court. I think that if we peel away, any language that involves corrupt judges, because it's an uncomfortable place to go, and we just focus on process, there is plenty here to look at process improvement. And I think it's very important we do that. These are very emotionally charged cases, and family court is where you're going to see the highest level of emotionally charged cases. But we have to be careful that we're not dismissing these complaints and allowing potential bad conduct to exist in plain sight because they are emotionally charged cases. We have to look, and we have to be attentive to that. Court rules, super important, and I think you have a great opportunity to understand the rules and gather data. My sister-in-law was involved in gaining custody of 2 young children that a niece had and providing support. She lives in Massachusetts. She's been a psych nurse for 40 years. She's been involved with child issues and guardian ad litem issues in Massachusetts. Her statement to me is, why doesn't New Hampshire try to improve the system and operate a little more efficiently like Massachusetts does? Because after spending $30,000 trying to assist these kids, she wanted to pull her hair out. And they're raising these 2 young children. She's 65 and her husband is 70. It's a huge commitment, and she has a very loving heart. She's all about the kids. She's worked with children her whole life. So I think there's an opportunity with a neighboring state to look at process down there as well. Deadlines, very important. The judicial system as a whole does not acknowledge, there's no regulations or laws that mandate when orders have to be issued. And the honorable representative from Wyndham mentioned that, a lot of complaints get filed by people who lose. I just filed a JCC complaint on a case I won. And I have a call at 1 o'clock with an AOC director to address a clerking issue in the court. I won, but I'm complaining because I thought the process was completely wrong. And it took 7 months to get something that should have taken 30 days. So I'm sympathetic to what these parents are saying. And I see children and families that are going 6, 8, and 10 years waiting for orders and parenting plans to be determined. It's too long. It's too painful. And there's too much trauma involved in that. So these stories could go on a lot longer, I can tell. And I think it's worth allowing them to be explored and to go on a little longer. Thank you very much.
And thank you for not going on a little longer. I really appreciate what you did there. That's good. The chair recognizes, and I'm trying to read red on pink, Michelle Leguminez. That's my fault, not, come on up. Say it again.
Michelle Lagimoni.
Where's it from?
I'm sorry?
Where's the country it's from?
Canada.
Canada?
Yeah.
It sounds Canadian.
Yeah.
Okay.
Thank you, everybody. Again, my name is Michelle Lagimonier. It is a bit hard for me to be here today because what I'm going to speak about is very real and it's happening right now, but it's important for me. It's important for me to be here. I'm in favor of HR 14. The failure of due process is very present in my current divorce case. I am living in a hostile and offensive environment. My mental health has been impacted. There is a cycle of violence that was going on in my household. I walked on eggshells. My husband's language made me feel small, inferior, and belittled. It was to the point of abuse, and it was a very volatile and difficult environment in my home. I've currently spent about $15,000 that I don't have in this divorce case. I am trying to get my word out when we have court cases, and I haven't been able to speak what I want to be able to say. I've had roadblocks put up. I've been accused of things that I haven't committed. And I'm trying to advocate for my daughter, who I have concerns about, and it just hasn't been able to happen. I've been fearful of my husband for quite some time. I have used avoidance tactics to stay away from him. Everything appears, in all intensive purposes, to look okay, but it's not. My husband, I believe, has a mental health disorder, but because I wasn't able to get it in the divorce proceeding at the proper time, in the proper order, it's not acknowledged. So again, I am here in favor of HR 14. I do feel it's very important. That's it.
Thank you so much. Thank you for your courage to come before us as well. Chair recognizes Vivian Gerard.
Thank you, Chair and members of the committee. As I had told you guys in the past, I have been to the Supreme Court 4 times, actually 5 appeals, 4 times with the remand coming back to the local courts. So I am a win-in case. I know Representative Bob Lynn said that it's only the people that are complaining that have lost. I am not that person. I won every single time for full child support to my children. I did have 2 bad judges. I had Indicaso and Delbro that both showed very much so unethical behavior. I did file JCC reports. Nothing ever came up at the beginning. In my case, Indicaso did not allow evidence to come in or allow motions to come in late from my ex, but I was not able to go ahead and put in late motions on my side as I needed to. I got blindsided. I was biased against from these judges. I have a 10-inch binder that I did not bring today, but I've brought it here before, that shows all the judges' discretions on my case. The judge allowed evidence. They're allowed evidence when they feel like it, or excluded it as they felt it was critical to that case. And in many times it actually had led to very profound disadvantages to me. And as I had spoke to you guys this morning about the wage assignments, that showed in many cases that the monthly obligation amount should not have changed. The only thing that was in dispute was the arrears based on all of these Supreme Court appeals. Every time something went through the court, it took at least 6 to 9 months each time a order went through the court system. For one particular order, it would take 25 months from the time the order came out to the time it actually went before a judge, and the judge turned around and said, no, I am staying to this order. And those orders were passed out to you this morning. So the timeliness between these events are too damaging to families. And the fact that judges are supposed to have 30 days to communicate back to people like me of why it's taken so long and what is causing the problems on these orders. And from my understanding, in my case, the judge is supposed to go to Judge King and let them know what has taken so long on these orders. Granted, in my case, I've had a long 9-year divorce. I've had 5 appeals, 4 of them that got remanded. For the judge to turn around and say that I didn't deserve child support for my children.
15 seconds.
Absolutely. I just think it's a disgrace. And I believe it's all feeding into this ecosystem that is provided. And it goes between the schools, the judges, and everywhere else. So I just think that this is a very good bill to support, to look into these ecosystems that are being fed by our ATMs.
May the chair say, well done.
Thank you.
This was good this time. And not representative, I wouldn't do that. Attorney Richard Head.
Thank you, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I do want to put into context sort of
No more pink cards. We are closed after this person.
What is family division. So, and I talked about this before, but we don't have a family court per se. We have family division, we have probate division, and we have district division. All are part of the court that we're talking about, which is circuit court. And circuit court judges hear cases in all of those divisions. So we don't have judges that just hear, they're not just hearing family division cases, but they're hearing the broad scope of them. And within the circuit court, what we have is about 127,000 new cases coming in every year. So we have 127,000 cases, all new coming in each year. And to handle that, we have 42 full-time judges and 6 part-time judges. It is a overwhelming workload. And sort of my point of bringing this up is some of the changes that are being implemented currently and what our Chief Justice is currently doing towards trying to bring some relief to what is a very stressed system. So within this year's budget from the Judicial Branch, the Chief Justice is asking for additional resources in the circuit court. I'm just going to focus on the circuit court. And he's asking that we have 7 additional judges into the circuit court. And to put some numbers to what that means, last year we did what's called a weighted caseload study with the National Center of State Courts. And what they did was evaluate how much time is spent by judges in all of their cases, very broadly stated. The Chief Justice did this presentation in about 2 hours. I'll do it in another minute. And what we know is that the total number of judges that we have adds up to what's called a session day, is the amount of days that a judge can sit. And with the judges we currently have, we have available 249 session days. I'm sorry, that's for each judge. So each judge can do 249. We have a total of about 10,500 session days in our system with our judges. So that's sort of the number that we have. If you take up the total time that all of those cases take for those judges, we have 10,500 available. It requires 16,300 to get through all those cases.
1 minute left.
Thank you. And what we're doing through the Chief Justice's budget is adding to our judges so we can add session days so we can bring some relief into the system. Separately, we have similar stresses in the court clerk system. We are bringing in, and we've asked for, and the Chief Justice has asked for 31 additional staff clerks within our court system to help relieve some of the backlog within the clerk system. I could go on. There's simply a great deal of stress in the system. And what you hear in what you heard today, some of the issues being length of time, delay, and trying to get cases moved through. What this bill would do would, as Representative Lynn said, essentially recreate what was in 2011 the Redress of Grievance Committee, where individuals can come in, talk about their case from a very one-sided perspective. This adds into it the ability to issue a subpoena to a judge to come in and talk about case decisions. They may even be cases that are live before that judge currently. They may be judges or cases that are on appeal. They may even be cases where the court has not issued an order yet and come in and have to, under oath, under a subpoena, testify about the very cases that they are evaluating and deciding. With that, I understand my time is up. I would be happy to answer questions or answer questions on the side if anyone has any. Thank you for your time.
Seeing no questions, this closes the hearing on House Resolution 14. We will reconvene for an exec session at 1:20. 1:20. I have suggested that Representative Lynn and Hole and Bernardi and former Representative Itza and probably my vice chair and anybody else come to see where we can pluck out some good stuff of this resolution and take into account the other aspects of it. Maybe we can square this circle, not sure. I'd like to see if we could try. Thank you. Be seated. All right.
Upcoming testimony has something to do with the executive session. This is an amendment to.
Opening the executive session on a number of bills, just to remind those who may be new to this. An executive session is not the second part of a hearing. Don't fill out pink cards. You will not be called upon. The chair occasionally will call on somebody for a clarification. If we're having a discussion and we don't understand something, at my discretion, I may call upon a person for a very brief clarification. Also, members of the committee and seat fillers, if you leave the room when the question is called and you subsequently return, you cannot vote. And calling the question is like this. Here's the motion before us, House Bill 789. The motion is ought to pass, moved by Representative Smith, seconded by Representative Jones. Would the clerk please call the roll? That's calling the question. If you're not in the room for that little speech and you walk in later, you don't get to vote. So I will try to signal the occasional courtesy break that we might need. All right. Opening the executive session on House Bill 306 relative to prohibiting reunification therapy.
You looking for a discussion or are you looking for a motion?
The chair is going to move to retain. And who seconded? Nice to see you. I mean, it's not unnice to see the others, but you weren't here. So chair moves retain, seconded by Representative Moulton. Anybody wish to enter into discussion? We thought that there was some good things in here, but it was a little generalized in its language. And as we continued to bat it around, you may remember we thought that if this bill were retained, there could be some good work done on it, and it could be brought up in the fall for a work session with then a vote which will send it to the floor of the House next January. Any further discussion on 306? Well, the motion before us is retain. Moved by the chair, seconded by Representative Moulton. The clerk may call the roll.
Chairman Pearson,
Yes.
Representative Long. Okay. Representative Disimone. Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon. Yes. Representative Ball. Yes. Representative Panic.
Out of the room.
Okay. Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Schuett. Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
14-0.
Oh, I'm a yes.
I apologize, Representative Seidel. I just skipped right over your name.
Yes.
What you were going to say.
And yes, she forgives you.
Thank you.
Alrighty, that does not need any reports to be written because we are going to keep it in the back pocket to take out in the fall, and that is when reports will be written.
Excuse me, Mr. Chairman, what was
Yes.
the total vote, please?
14, that's the clerk.
14-0.
All right. All right, next up, it doesn't have, yes. Okay. Next on the calendar is, that concludes whatever we just did, 306. Okay, now open the exec session on House Bill 535, requiring an attorney for a child and so on. I have one amendment before me. Is there another amendment that is being presented? We have one amendment entitled 0611. That's found in the upper left corner. But is there another amendment that has been worked on and given to a member of this committee to present? All right. The chair will entertain a motion with the amendment on it. And that will be Representative Seidel. Will do this to make up for your being inadvertently ignored previously. What is your motion?
Thank you, Mr. Chairman. Mr. Chairman, I would wish to move House Bill 535 with Amendment 0611H.
The motion is move House Bill 535 with Amendment 0611. Is there a second?
Yeah, I'll second.
Thank you.
But, excuse me, Mr. Chairman, she'd like to move it what? She didn't say on to pass.
She didn't? You didn't?
I guess I did not. To pass,
Would you like to?
I would.
I thought so. Thank you.
An OTPA, correct?
It would be an OTPA. Now, let's take a look at the amendment. Remember, we had numbers of questions that came up, and I assume that Representative Hall has addressed those. Let's take a minute and read through it. All right, are we ready to discuss? Representative Moulton.
Thank you, Mr. Chairman. So I have some issues with this bill. The original bill, I'm not talking quite about the amendment yet, doesn't necessarily say that the child's expressed interests are in where. So if the child's expressed interests conflict with the recommendation from the guardian ad litem, but my issue with that is that sometimes kids don't know what's in their best interest. So, which is why they need adults to make decisions for them. If they could always make the right decision, then they wouldn't really need parents. And in this case, they wouldn't
They need
a-
parents for money.
Well, so for example, I can use my teenager for an example that, you know, if he you know, made a mess and so and he didn't clean it up and I gave him till a certain time frame to clean it up and he didn't, and so I, you know, turned off his cell phone for the weekend or something like that. Most people would say that that's an appropriate punishment, but that would be against the child's expressed interests. And so, because he would want to keep his phone, but also not have to clean up a mess because he's a teenager. So, so my issue is that sometimes children, you know, I don't think that it would be appropriate for an attorney to get involved just because a child's expressed interest is in conflict with a guardian ad litem. I think that opens up a can of worms.
I wonder if lines 22, 3, 4 help us that the child can waive that off. In other words, the child could fire the attorney if the child wanted to. It's not demanded. It's just giving the child another resource. Counsel would counsel. Maybe say you don't want to do that. Could be. Anybody else? Representative Raymond.
Thank you, Mr. Chairman. And thank you to Representative Hull, who has put quite a bit of work into this, making the amendment and bringing it back to us. I see a lot of the things that we had discussed in this amendment, and I really appreciate that. I also see some of the concerns that CASA had are addressed by this amendment as well, and I appreciate that. I'd just like to highlight there are some significant changes in this amendment from the original bill, some of which I think are really great, and others I'm still concerned about the language. So under line 9, 2A, it says the court shall appoint an attorney to represent an indigent parent alleged to have neglected or abused his child. I cannot express my support to that enough. I worked for DCYF back in those years when parents didn't have attorneys. There was like 2 years where they weren't being appointed attorneys, and it was terrible. Everyone deserves to have an attorney giving them advice, so I agree with that completely. B on line 16 is great. C, it says on the date of filing, the court shall appoint an attorney to represent the child's expressed interest for children 12 years or older. I appreciate that there was an effort made not to give, 6-month-olds and 2-year-olds attorneys as a matter of rote, because we all agree that that's probably not people's best choice, but there are circumstances where those kids might, and this allows for it. So I appreciate that. But I'm concerned about section number 21 to 25 regarding letting the child essentially waive having an attorney. I don't know that a 12-year-old who gets mad at their attorney should be able to waive that advice. They can say, I'm not going to follow it, but that worries me. And the other big concern that I have with it is we haven't done any kind of research to find out where this pool of attorneys is going to come from. And I don't see anything in here about who's going to pay for these attorneys. And I don't want parents to be unnecessarily burdened with additional legal fees. And I don't want our system to have unnecessary backlogs if we simply cannot find attorneys who are, let's assume, willing to do whatever the rate is that the state decides. I'd really like to see this bill still retained a little bit longer so that there can be some sort of an investigation. Honestly, I would put it in the Office of the Child Advocate to find out where are we in our attorney situation? What's the staffing levels like? What's an appropriate compensation? What are our neighbors doing for compensations for this? And where is this money going to come from to pay for these attorneys? I really hesitate to rush into appointing attorneys to kids when we don't have a mechanism financially to pay for it without burdening parents further. And I can't get my mind around the financial impact yet. But I can see myself getting there if we have a financial plan, which unfortunately still isn't attached. So
Let me speak a little bit here, and that may, because I think it may dovetail. If you go back to lines 18 to 20 of the amendment, shall appoint an attorney to represent the child's expressed interest. Turn to the next page and look to line 2. Line 2 says this section will kick in July 1st, 2025. The reason that is there, I believe, is multiple. Number one, it gives the Bar Association 2 years to learn how such appointed attorneys to children would function. It will be not in the budget cycle we're working on now, but in the next budget cycle, at which financial questions about this, I believe, could be addressed. And the third one about what do other states do, we have a mechanism in the Oversight Commission on Children's Services who can do exactly that, finding out what other states do and when it works, and finding out still other states where maybe it didn't that we could learn from. So I think some of those questions that were very wisely raised, I think they have some answers to them. Representative DeSimone.
Thank you, Mr. Chair. I wanted to talk a little bit about the representative's concerns, and rightfully so. However, we're the policy committee, and this is an early bill because it will go from here to finance, and finance will figure out who pays, how much they pay, when they pay, where they pay, and so forth. So for this bill, we're really supposed to be looking at what's in front of us, which is the policy of the bill. And I don't know if that will help the representative with her questions or not.
Representative Long.
Thank you, Mr. Chairman. I wholeheartedly agree with Representative Raymond. The fact that this is extended to 2025 tells me that it's not ready. I agree with attorney appointments. I mean, we all received NCAA's latest study, I believe it was. And from what I got out of reading that 70-something pages is the importance of training. So where are we going to get the attorneys? It is a good point, because with that will come training for trauma-informed attorneys to use with these children. And the fact in 2025 that this kicks in 2025, we're in finance drafting a budget. So this kicks in when there isn't a budget yet. We don't know where the money is coming from as of 2025, as of January of 2025. As in B and C, 16 and 18, the May, and then the 12-year-old, there are some 7 or 8-year-olds or 9-year-olds even. So I want to be sure that we're helping the children that need the help. In my mind, supporting this, in my mind, would be better than nothing. And I don't want to be better than nothing. I want to be what we believe is the best interests of these children. Thank you.
Representative Bickford.
Thank you, Mr. Chairman. I have the same issues that Representative Raymond last brought up and about the, mostly about who's paying here. But I don't think we should pass this bill or try to. We might actually get a count of 10, 11, but we need to get something like this that looks as complicated as this to the full assembly. We need a pretty good vote. So I'm going to recommend that we consider withdrawing the motion of ought to pass and go with a retain, because I think we can polish this up so we get most of the whole committee on board. And that's what we're going to need to get this thing through to the Senate.
Representative Stewart, welcome.
Thank you, Mr. Chair. I just wanted to point out it was stated that this was an early bill. However, I believe it is.
This is not an early bill.
Well, that's what I was going to say. If it was, it was supposed to be on the calendar tomorrow or Thursday.
This is not an early bill.
Thank you.
Representative Moulton.
Thank you, Mr. Chairman. If we're discussing some other changes that we might want to entertain with polishing this up, I agree with what Representative Raymond was saying, for the most part, for the vast majority, but also on line 18, the child who is 12 years old or older at the date of filing, I realize like a lot of things happen when a child is 12, but it also seems a little bit arbitrary to pick 12 as opposed to 10, as opposed to 8, as opposed to, so I would like to see maybe, and I could be the one to kind of look it up, especially if we're retaining in this in committee and we could come back to it later, see if there, what other states have on file for that age, see if there's some research available for what age, but unless there's evidence that 12 years old is the time where a child should have the attorney, like maybe we want to amend the wording to give a little bit of leeway, what's wrong with an 11-year-old, what's wrong with it? It might be a little bit case by case specific. So we would want to put language in that for there. And we might want to pick a different age.
We have a suggestion that we can act on, and that is, the suggestion is, would the sponsor and second wish to withdraw so that the bill could be retained and further worked on along the lines of what was suggested? I'm not calling for a vote, I'm just calling for a kind of a sense. Is this something we might want to do? Your heads pivot up and down or left to right? I'm just looking. This is not a hint.
So you want to withdraw your motion? And I'll withdraw my second.
What do you think? You made the motion.
I'd be satisfied with retention, with withdrawing the OTP.
You have to withdraw your motion.
I
in
withdraw
order
the
to withdraw your
motion
motion.
to pass with amendment.
Okay. Okay, now we have no motions on the floor, and the chair will entertain a motion.
Oh. He can't see me. I have a motion. I did.
I need one of those little upsy ovary periscope thingies.
I could pick up my cane and like thump it or something. I don't know.
That's tacky,
Oh.
and you are only adjacent to the rowdy section. You are not in it, so. Go.
Thank you, Mr. Chairman. I move that we retain HB 535. Oh, do I have to say the amendment number? What's?
No, because now it goes back to the original bill.
Oh, I don't, but I like the amendment mostly.
If we retain it, there's no reason why the amendment language cannot come back in its glory with even more improvements.
Okay,
If you-
yes, that's what I would like to do. So I move that we retain HB 535, please.
And you'll never guess what the chair needs right now. Thank you. Any further discussion? Now, the word retains has two meanings in the dictionary for us. One, it means death with dignity. We hate it, but we don't have the courage to say so. Or it means we're going to keep it and we're going to work on it and we're going to take counsel with each other and we're going to run back and forth and make this until, everybody stands up and cheers. That's what I'm hoping this is, okay? Anything further of discussion on the motion, which is retain? Moved by Representative Raymond, seconded by Representative Bickford. The chair recognizes Representative Moulton.
Thank you, Mr. Chairman. For the freshmen at the table, when does something that's retained come back? Is it something we work on during the summer?
We can work on it during the summer. Into the fall, we will have a meeting of this committee sometime in the fall to pick up two already retained, and it looks like maybe a third one and others. And we will work on them and we will vote on them. And we will make our recommendations, and you will write a wonderful blurb. And then early in January, we vote on it.
I see. Okay. Thank you.
Welcome.
Along the lines of what she just pointed out, we used to do subcommittees along the way. And now I notice we're not doing that so much. I do know that retain usually gives us more ability to look at it than a subcommittee. Is that the idea? Usually it's the chairman that appoints a subcommittee. Are
Yes.
you purposely doing it this way rather than subcommittees?
I'm not purposely doing anything right now except try to get a vote. But what I would be interested in is in a week or two, I will announce the different bills we've retained and ask of you which ones you would like to be on a work group of.
Well, it doesn't answer my question, but okay.
I know that. All right. I have called the question, and now the clerk may call the roll. The motion is to retain.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone. Yes. Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino,
Yes.
Representative Schuett,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond,
Yes.
and that's 16 yays.
How many
0 nays, sorry.
Add that to the retain pile. Next, and this will close the exec session on House Bill 535, and I open the exec session on House Bill 471 relative to final disposition hearings in divorce proceedings. The sponsor of this bill is Representative Yokela. Chair would entertain a motion. Representative Ball. For a motion.
Yes, I'd like to make a motion that we OTP House Bill 471.
All right, yes, the motion is OTP by Representative Ball. Do we have a second? Who said second? Second, Representative Panic.
Second it.
Discussion. Representative Long.
Thank you, Mr. Chairman. I certainly understand the need for final disposition hearings, given people reliance on this will end in some time. But I believe that this bill has written is a false sense of a final dispositional hearing. I don't believe this changes anything that we've been hearing in testimony coming before us. So I'm not in support of the ought to pass.
Representative Gregg,
And I second that,
you're welcome.
Oh, no, that I would, Representative Longson, but thank you, Mr. Chair. Sorry, I cannot remember that part. I'm usually better with manners. Divorces are complicated, as we all know, whether you've been in one or not, but I think that what this bill is wanting to do, which would be to help streamline it and make it more predictable, I think it's actually going to have a catastrophic backswing the other way. The reason being is that you might have one divorce that could take like 30 days, and then you have another divorce that could take years. The problem is if the judge has to set dates as soon as these come in, and you don't really know whether or not you want to try to reschedule it later or anything else. Let's say you're the first in the year, but they have 6,000 cases. Well, by the time you get to the end, how many years off are you setting some of these divorces that could have been 30 days? All of a sudden you have one that could have been quick, but because they had to set dates ahead of time, now all of a sudden you're pushed out years because all these dates are filled. And then saying, okay, now we had a cancellation. You're on a cancellation list to come in earlier. I think it actually further complicates the court system.
Thank you. Representative Raymond.
Thank you, Mr. Chairman. I share the same concerns as my colleagues. This morning, we heard a lot of really moving testimony on another issue on HR 14. And in part of that testimony, it sounds like there's a general consensus amongst people involved in family court, and certainly with the judicial branch itself, that the family court is taking a significant amount of time to resolve some of these cases. And so I think it's laudable to try and come up with solutions. But what we heard today is that they have 127,000 new cases each year, and we're down 42 full-time judges to make all of that happen. So I know that they're requesting additional judges in this coming budget year and a significant number of additional clerks. And I would urge us to see how additional staffing assists and get staff onboarded before we start requiring scheduling of things. Because I really hate the idea of someone coming in and filing for divorce and then hearing that their final hearing isn't going to be for 24 months. Because I'm afraid that if we pass this now, that the court is going to err on the side of, well, this is our next free day for, to schedule these things, because we have to keep open time in the meantime for the other 126,999 cases that we know are coming. So my feeling on this is that now is not the time.
Representative Moulton.
Thank you, Mr. Chairman. The other unanticipated consequence that we might end up seeing with if this bill was executed as written, I know in my case we had a temporary hearing in October, and they gave us the date of the first day after January 1st, which came and went, and it never actually came to fruition. So we might end up finding that in order to meet the rules of the statute, that judges are just throwing out these dates and not actually meeting them because the dockets are so full. So if they're not actually coming to fruition, then it's a useless bill. So.
Thank you. Representative Ball.
I believe the purpose of the bill was to
You're
get.
welcome.
I'm sorry. I'm terribly sorry. Excuse my poor manners, Chairman Pearson. Thank you for recognizing me.
At least it's bipartisan.
Thank you. I don't normally speak. I'm trying to stay quiet all the time. Anyways, I believe my understanding of the bill was pretty much to get the people into the queue because it is taking so long. So rather than having them work on their divorce situations and then decide, okay, well, let's get on the docket and then find out the docket is a year or 2 years out when they've already lost however many months. And I believe that in testimony, they were also saying that as we keep people hanging and waiting in limbo to get onto the docket, it causes more damage to the minor children who are going through the trauma of the parents who continue to fight. It's costing the families more money because more motions are being filed, tensions are getting higher, and a lot of that is just from frustration in waiting to have their court case heard.
I'm trying to peek into every corner. Anyone else? No? Representative Bickford? Sure.
I too am not ready to go forward with this bill, partly because it gets into divorce. It should be broader than divorce. But the main reason is we heard from Richard Head that there's a real serious problem with getting cases in such on the docket in the right place. And I believe they're trying to do something about it. I talked to Judge Lid at Finance, and there's seems to be a money issue with 127,000. What was it, 1,000 or? And I guess I get lost. The number's so high, and I think I'm not ready to jump in and start tinkering with the machinery of the court. And this is what this is. This is about tinkering with their system, and it doesn't mean it shouldn't happen. And I may be completely wrong at this point, but I'm just not ready to jump in. So I'm going to have to vote no on the ought to pass.
Thank you. Anyone else? The motion before us. Representative Panic.
Thank you, Chairman.
I do have an
for
eye
taking-
doctor's appointment on Friday. I missed you. I'm sorry.
I just got my new glasses.
How they doing?
I can see you now.
So the eyes have it.
Yeah, that's right. Is there a way that we could move to ought to pass under the condition that we try and get more judges?
No.
Just asking.
Good idea.
Thank you.
We're trying to get more judges. Believe me, a lot of us are trying to get more judges. I'm not going to law school after all. I was afraid they might pick me, and I don't want to do that like this. No. Anyone else? And I don't think this is one of these bills that if we retained it for 6 months, we could square the circle. I think it's either we say it or we don't say it. I'm not sure if there's a middle place. Is there? You
Well,
think?
you can, of course. However, I'm looking forward to HR 14 to help resolve some of these issues. And as I said, I talked to Judge Lynn about coming in with an amendment for that one and seeing if we can start get together on these issues and go from there.
But meantime,
In the meantime, yeah, you can, but I don't think it's going to buy it a whole lot.
now, last chance. Seeing no other hands other than Representative Ball.
Thank you, Chairman Pearson. I would like to just point out that in testimony, it was told that in criminal court that everything is scheduled right up front. And I just question as to why in divorce proceedings that the parents or the two parties that are seeking to end their marriage aren't given the same courtesy, even if it's scheduling out 24 months. At least they have an idea of when they're getting out of court, rather than just kind of languishing there and just in a state of limbo of not knowing what's happening. How do they plan their life ahead? Maybe they want to move on. Maybe they want to, let's just allow the court to be honest with them and tell them when they're can expect that they're have a final hearing. Thank you.
Representative Moulton.
Thank you, Mr. Chairman. I do think there's some value in letting some time elapse. I did in my personal situation, I didn't see the value in that, and I wanted, I know what I want to ask for, and this is what we need, and blah blah blah. But as time elapsed, different issues came up that we couldn't foresee in the beginning. So having that time elapse, having, my soon-to-be ex and I try to resolve them, and, some things were able to get resolved, some things weren't, things like that. The time is a little bit valuable. It's frustrating, and, not having the orders that you want muddies waters and things like that. But by seeing different issues that have popped up, we can get that language into the final decree when we get it. I think, to answer your question, I think that because with a criminal case, it's not ongoing, like one thing happened and that was it, whereas with child and family, things are always evolving and situations are always, changing and stuff like that. So.
Representative Bigford.
I just happen to think that the advantage of a retain would be that this could come back next year. If we don't retain it, we have to wait 2 years for it to crop up again.
Mm-hmm. It's true. Anyone else? Then I'll call the question. The motion before us is on House Bill 471 FN relative to final disposition hearings in divorce proceedings, moved by Representative Ball, seconded by Representative Panic. The motion is ought to pass. When the clerk is ready, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
No.
Representative Disimone. Representative Bickford.
No.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will be voting no. Representative Schuett.
No.
Representative Gregg.
No.
Representative Moulton.
No.
Representative Raymond.
No.
OTP fails 7-9.
Chair now entertains, we have to have a dispositive motion. Chair will entertain a second motion. ITL. Representative Bickford, are you making a motion?
To retain.
That is in order. Does anyone wish to second the retain?
I second it.
All right. Any further discussion? Representative Moulton.
Thank you, Mr. Chairman. I'm not sure what value retaining this would have. I mean, either they can clear the dockets and hire more judges or promote lawyers to judges, or they can't, and that's a complicated issue. So I would be concerned that retaining it isn't going to help fix up the language to make this bill that could actually be executed. So I personally would be in favor of ITLing it, but the motion on the floor is to retain. So
You should defend your retain. You were going down a line of thought there a minute ago on this.
Right. Well, my reason for retain is if we should learn during retain that the court really hasn't done their job the way they should, and we feel that they can be directed by the legislature, we would be able to come forward next year. I think it's in January. Usually the retained bills are acted upon. Or we could just, at that time, let it go. So that's the advantage. You gain a year if it's useful.
What a quiet bunch. Gosh. Even the rowdies are quiet. Yes, Representative Moulton.
I'm here now. Thank you, Mr. Chairman. So I'm just wondering what would if we retained this, what would you suggest that we would do? Just call each individual court and ask them, like survey them, so to speak, about what issues are the stop block on the docket, but we would have to call every single like court in the state. I'm just wondering, just in good faith, asking in good faith, how we would find out this information.
Well, I start by, thank you, Mr. Chairman, by going back to Mr. Head, who comes here for the court system, and then you'd ask him if you couldn't interview some people, and you may want to take some statements from other people, which I think will just show up anyway. I don't expect it would take a lot of time, maybe a couple meetings, and then you'd sit on it, wait and see.
Representative Long.
Thank you, Mr. Chairman. We just heard an HR 14, which is going to look at all this stuff, and what Representative Bickford's alluding to, that if we retain this, we could bring it forward then in January. If we ITL it, it won't come back for another 2 years. So there may be a fix that we could put in good language for this. So that's that reason. So I'm going to support the retention.
Also, I always go looking for what do other states do? Do other states have this kind of thing? They have people with problems and judges on benches and so on, and what do they do? And I hate to say, I will ask my research committee research assistant to do it, but I know she will. Thank you. You have until September. Anyone else? Motion before us is moved to retain House Bill 471 FN relative to final disposition hearings in divorce proceedings, moved by Representative Bickford, seconded by Representative Panic. Clerk, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrina will be voting yes. Representative Schuett.
Yes.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
Retained carry 16-0.
16-0. There is no reports that need to be written. The work will happen at a much later date. The motion to retain carries. Ends the exec session on 471. I now open the executive session on House Bill 479 FN relative to the confidentiality of records within the Division of Children, Youth, and Families. And the chair looks to Representative Panic for a motion.
I motion for ought to pass.
Thank you. And do we have a second? Representative, is that DeSimone? Representative DeSimone. Discussion.
Mr. Chair,
Yes,
can I just make a correction? It
you may
is,
make a correction.
House Bill 497, not House Bill 479.
Did I less Dixit that?
Apparently so.
Apparently so. 497. Thank you for the correction. Discussion on the bill. Representative Raymond.
Should I go up instead of out? I don't know.
Yes.
Thank you. Thank you, Mr. Chairman. I cannot support this bill. I don't see that anybody has submitted an amendment, and my concerns remain the same that they were when it came before us a few weeks ago. So this bill basically is making an allegation that DCYF is not providing families with records the way that they ought to be. And we received significant testimony that already DCYF is required to give parents their records, but they have to submit a request and then they have 60 days to do it. However, DCYF doesn't currently have the staff to always meet that 60-day thing. Furthermore, we learned that if you have an open assessment that has not had a finding made, unfounded or founded, you're not going to have the records. And if there is a case where the police are involved, you're not getting the records then either, because then you're obstructing a case that the police are doing and nobody wants to get involved in that. So this is a bill that seeks to solve a problem without really getting to the basis of what the problem is or if there is a problem. The last reason that I'm going to oppose this is that I think that part of the germane point of the bill was to try and access other records. So if your child or your family is involved in DCYF, DCYF is going to collect records from the schools, from the pediatrician, from a therapist, anyone that a parent signs permission for DCYF to access records from. DCYF is prevented, based on HIPAA, from re-releasing those third-party records. There's literally no way that DCYF can legally give you what the pediatrician gave DCYF. If you want that information, you need to go directly to the pediatrician or to the school or to the therapist. And then you have a right to have it because you're the parent. So I think that, again, I really think this is a bill based on someone's personal experience where they didn't feel like they had a good experience, and now they're trying to legislate based on one example. And I don't think that's an appropriate use of our committee time or legislative powers. So,
Anyone else with a comment on the bill? Seeing none, the motion before us is ought to pass on House Bill 497 relative to the confidentiality of records within the Division of Children, Youth, and Families, moved by Representative Panic, seconded by Representative DeSimone. Will the clerk please call the roll?
Chairman Pearson,
Yes.
Vice Chairman Long,
No.
Representative DeSimone.
Yes.
Representative Bickford,
Yes.
Representative Nelson,
yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrino,
No.
Representative Schuett,
No.
Representative Gregg,
No.
Representative Moulton,
No.
Representative Raymond.
No.
The vote is 8-8.
It comes out of the committee with no specific recommendation. There needs to be, on the OTP side, someone to write the blurb. Who would like to do that? That's those of you who voted yes. A committee report has to be written from both sides. Representative Long, work your side of the room.
Representative Raymond will do the
Oh.
ITL.
I just assumed I was being voluntold to do that, and that's fine. Thank you, Mr. Chairman. Vice Chairman.
Okay. Representative Panic will write the OTP motion, and Representative Raymond will write the ITL motion. Not motion, report, committee report. Good. Ready?
Mr. Chairman,
Yes.
can we go back for a second to House Bill 306? We voted to retain.
We did.
And can we put that on consent?
No, it doesn't go
Oh,
on
it doesn't
consent.
go there. Thank you. I'm sorry.
It goes
Thank
in
you.
my back pocket.
Thank you
okay?
for correcting.
No, hey, come on, we all helping each other out here. You know, untwangled my numbers a minute ago. Okay, this concludes the executive session on 497. And with that opening, I will open the hearing on House Bill 185 FN relative to the determination of parental rights and responsibilities based on shared parenting and shared access to the child's records. And I believe Representative Post will come forward on that. Let's find my folder. 185.
The testimony forms. Oh, can I just get two? Yeah. Take one home and write those out.
And believe it or not, this bill has the correct sponsors.
You're kidding. What's the likelihood of that? Let's see.
The chair is going to be passing around an amendment by the bill's prime sponsor. And the reason I do that is not that we can necessarily vote on it unless we choose to go into an exec session, but because very often the bill is originally written, had a journey on its way to us, and this will give us at least a chance to see what the prime sponsor is thinking. So that's why you're getting this piece of paper.
Mr. Chair? Mr. Chair?
What?
If I may, I will take my leave. I will take my leave now. It was a pleasure to serve. Thank you.
Yeah, because he refused to take it. It was late, came in late, so the chair refused to take it. Yeah. On another bill.
The chair recognizes Representative Post.
Thank you very much. For the record, I am Representative Lisa Post, serving Hillsborough 42, that is Lineborough, Mount Vernon, and New Boston. My thanks to Chairman Pearson and the committee for the opportunity to introduce House Bill 185 relative to the determination of parental rights and responsibilities based on shared parenting and shared access to the child's records. This is a constituent bill that was authored by Gail Drobat, and she is, Drobat. She is here today to testify on her behalf. She is the author of it, and she has worked on this bill for a very long time, and I will defer to her on the questions regarding her bill. I come before you today to improve the lives of children and strengthen society by protecting every child's rights to the love and care of both parents after separation or divorce. Mr. Chair, I believe you'll agree with me that this bill has been before this committee and House many times over the years, and many legislators have come before me with similar bills that have passed both the committee and the House, but never made it into law. For many, the court system is not working for children who do not have regular contact with both parents. And I think you heard in HR 14 this morning, a woman named Linda who was talking about the process. The process is broken, it takes too long, and it leaves families in a very bad state. The child's best interest is to have the benefit of both parents, and our Constitution provides just that. Children's rights are provided by their parents' power and duty to protect the health, education, and well-being of the child. There is a growing and compelling consensus among researchers that true shared parenting is usually in the best interest of the child. Moms and dads have different talents, skills, and approaches to life, and this creates a diverse environment for the child to learn, grow, and be confident under the care of their parents. Our laws should be clear and concise, that no parent should be denied the ability to execute their duty and power to protect the rights of the child, regardless of separation or divorce. Several states have recently passed legislation beginning with the presumption of joint custody, which is in the child's best interest unless the courts find there is an abundance of clear and convincing evidence of abuse and neglect. And that is something that they are using the language in so that the courts really dig into what's going on. My hope that this is the year of the child to thrive with both parents in their lives, and I ask for your support in passing House Bill 185 to protect our children and support our New Hampshire families to live their best lives. Mr. Chairman, I am not a subject expert, and I would request to defer questions to others more knowledgeable than I. But if you have a question that you think I can answer, not being an expert, I'm happy to do so.
Seeing none, thank you so much. And the chair recognizes the aforementioned Gail Drobat.
Actually, could I have Karen Calabro is here. She's a PA, and she can testify to that on how the effects of children. On...
We'll get to her.
Okay, thank you. She
everybody
does have a
gets-
time constraint at 3 o'clock, so thank you.
Who is?
I have a pink card.
Oh, you didn't have a pink card?
I didn't put one in.
Oh, sorry.
I will certainly. What is the name? I didn't put in a pink card. This is my first.
She didn't put it in, so
Okay.
My first, sorry.
she'll fill one out.
Okay, you can forge it.
Okay.
Okay, so the chair recognizes State Representative.
My name is Karen Calabro, District Hillsborough 45.
Okay, welcome. There's only like 6,000 of us here, so that's why.
I'm speaking on behalf of the, as primary care provider to the homeless. I got to see a lot of people kind of falling through the cracks. I see a lot of families that are undergoing a lot of upheaval. Unfortunately, it is my population that is very oftentimes the people whom you are talking about. The number one thing that I can tell you as a predictor of failure is a disengaged parent. Whether it be through geography or through financial means or through by choice. A lot of them have addiction issues and whatnot that'll oftentimes keep them from it, and that would make good sense. But assuming that these people have an interest, I have seen more fathers squandering waiting to see their child than I care to count. And their sobriety is on the line, waiting so that they can have that stability. So I'd ask you to consider this bill. Thank you. Thank you, Chairman.
And I thank you for your time. Do you have any questions?
How soon before I get the pink card? Okay, good, thank you. Any other questions?
So we're good. Thank you.
Thank you, Representative. Now the chair gets to call Gail Drobat, mentioned as a prime source for this.
Thank you, Mr. Chair, members of the committee, for the opportunity to testify before you today. For the record, my name is Gail Drobat. I reside in Amherst, New Hampshire, and I come before you today in support of HB 185. As our elected policymakers, you have the greatest ability to create and reform outdated laws to better protect the children of New Hampshire. I am before you respectfully requesting your support in passing this much-needed legislation. HB 185 is to protect the children's rights. This bill will allow children the right to equal access with both fit parents, this may be rebutted with clear and convincing evidence that it is not the best interest standard. Each parent brings valuable meaning and lessons to life, the lives of their children. Children have fundamental liberty interests in free association with both parents. The court cannot act in a child's best interest if it fails to protect the child's fundamental liberties. Judges are deciding fundamental rights of children and making life-altering decisions that will impact their lives forever. New Hampshire, Chapter 461A, Parental Rights and Responsibilities, A2 states in part and codifies that children do best when both parents have a stable and meaningful involvement in their lives. It goes on to state, unless clearly shown in a particular case it is detrimental to a child, that the state will support frequent and continued contact between each child and both parents. The standard orders are typically a custodial parent with the majority of parenting time and a non-custodial parent relegated to an every other weekend visitor. This does not constitute frequent and continued contact with each child and both parents. These rights are already presumptively in statute. HB 185 codifies 50-50 shared parenting, which may be rebutted if it's not the best interest. Decades of social science research favors the closer to equal time a child has with each parent, the better outcomes for children. This bill will allow an even playing field. Parents knowing going into separation or divorce, the child will have equal access with both parents. They will no longer be litigating petty grievances or making false allegations of abuse or neglect to gain the upper hand in court proceedings. Less litigation frees the overburdened dockets from unnecessary litigation. I believe it is the appropriate time to pass House Bill 185. We need to legislate good policies that work for most citizens. This bill does still protect children from abuse and neglect, and that is in our statute already. Thank you.
Thank you for your presentation and all the hard work you're doing. Chair recognizes Mary Kruger from the New Hampshire Legal Assistance.
Thank you, Mr. Chair, and thank you, members of the committee. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. We're a statewide nonprofit law firm providing civil legal services to low-income clients and seniors to meet their basic needs. We also operate a domestic violence advocacy project where we represent clients who have been screened in for high lethality domestic violence cases. Those are the kinds of cases where there's a likelihood that someone could be killed. We do protective order cases, and we also do divorce and parenting cases. I'm here to oppose HB 185. My colleague Erin Justina did circulate some written testimony in addition to an article from the Battered Women's Justice Project to also talk about this issue. I'll just highlight that a main reason why a parent may stay in an abusive marriage or relationship is to protect the children and for fear that the children will be taken away from them if they do leave the relationship, because that's often a threat that's used to control a victim who's abused, in addition to financial control. And sometimes the courthouse is the last place where an abuser can exert that control and manipulation. That fear that a victim may have for their own safety and their children's safety may cause them to decide to stay together. If a bill like this passes, where the presumption is equal parenting, that could just cause them to remain in that relationship for fear that their children will spend time with an abusive parent. The current law, where the presumption is frequent and continuing contact, has worked really well since 2005. I've been to this committee several times. I've worked on a commission or a committee over the summer to make some tweaks to that parental rights and responsibilities law in order to ensure that really frequent and continuing contact is the policy that's stated in the law. We've inserted it into a couple of other places, including in the best interest standard that currently is in the law. And so courts are very aware of that. The other thing that is concerning about this is it creates clear and convincing evidence as a standard. Currently, the standard for a court to determine what's in a child's best interest in terms of parenting time is preponderance of the evidence, and that is like a lower standard. Clear and convincing evidence is a higher standard, and it's very unusual in the civil context to be utilized. So it's harder to demonstrate and prove. And what I see this doing is it really undermines the ability to analyze what is in the child's best interest, elevating a children's rights over parent rights. And this is a parental rights and responsibilities law. So this committee really needs to think about the change in the policy that it would set in adopting something that elevates the child's rights above a parent's rights, which it potentially could do, and is an interesting dynamic that I hadn't actually considered until I sat and listened to the testimony before me. So those are some of the reasons I would caution moving forward with this, and I'll happy to take any questions.
My question is, you would not have this before you, it was just given to us, but would you believe that in the amendment, rebuttable is evidence of abuse, including evidence of abuse is defined, and it gives several RSAs, or criminal assault or abuse. So the idea of co-parenting, if one parent may be an abuser, is specifically rebutted here.
I haven't seen the amendment, and I'm happy to take a look at
Okay.
that and provide further testimony on that. The concern is the clear and convincing evidence standard as well, and I think that really elevates the ability for somebody who's already having a hard time articulating, because of trauma, the kind of abuse and the effects of it and whatnot.
Representative Moulton.
Thank you, Mr. Chairman. So my question is, with the clear and convincing evidence, they don't just take word of mouth for evidence, right? You need photos of abuse or some type of documentation of financial abuse or something, right? If my understanding is correct. So say something happened, 10 years ago, and the parties are like one party's being more contentious during the divorce, you couldn't be able to go back in time and say, oh, well, they're abusive, they've been showing abusive patterns, because that's not clear and convincing evidence. Is my understanding correct?
Somewhat. I think you would need to have more corroborating evidence, which is what I think you're talking about, in
Right.
addition to somebody's testimony. Testimony is very powerful evidence in a case of somebody's experience. But the corroborating evidence may be required, which is hard to come by when you have domestic abuse that is often behind closed doors. And so you often don't have the advantage of having other witnesses to have seen what's occurred. So that is a concern. What is also concerning is that we've never used that standard for deciding what used to be called custody. In 2005, we replaced all of that language for a reason, because we're not talking about children as property anymore. But that's a standard that we've never used, and it's very unusual in a civil case to use that standard. That I can't, even off the top of my head, think of when that standard comes into play in civil matters.
Thank you.
Representative Raymond.
Thank you, Mr. Chairman, and thank you so much for taking my question. What is the current standard in family court cases when we're talking about parenting time or allegations of, domestic violence or other allegations?
It's a preponderance of the evidence, which means more likely than not. And under 461A, throughout, it references RSA 173B or the child abuse statute. Those two statutes that the court would use those statutes to define what constitutes child abuse, neglect, or domestic violence. And that you would have to prove by a preponderance of the evidence that there was domestic violence or child abuse or both present in order to, help the court to understand or decide that there would be something other than frequent and continuing contact. The court's also looking at the safety of the abused parent, the safety of the child, and both, and the effect of the abuse that might have on the child. So it's not like a done deal if you demonstrate that there's been domestic violence, that under RSA 173B, that there's going to be something less than frequent and continuing contact. You still need to demonstrate why it's not in the child's best interest to have that contact with the abuser parent.
Okay, follow up.
Follow up.
Thank you, Mr. Chairman. So for people who aren't, frequently in court and get most of our information about court cases from like television, what is the significant difference that we need to know about the difference between preponderance of the evidence, clear and convincing, and then the criminal statute of beyond a reasonable doubt? Like, how do I put those in line in my brain so that I understand where each one falls on a continuum of evidence?
Sure. So preponderance of the evidence is like the easiest burden of proof. It's more likely than not. Beyond a reasonable doubt is the highest standard, for a criminal case, where if there's any doubt, then you're not guilty. So this is sort of in between those two. And that's the best way I can describe it. I think there's some subjectivity to that, but that's the best way to describe it.
Thank you.
No further questions. Thank you for your testimony. The
Thank
chair
you.
calls Dana Albrecht.
Good afternoon again, Mr. Chairman. For the record again, my name is Dana Albrecht from Nashua. I'd actually like to begin by just rebutting a couple things I heard earlier. I think right now, in practice, in these abuse cases, the plaintiff is presumed to be right with no notice to the defendant until somebody shows otherwise. And I believe also in practice, in some of these abuse cases, we let in multiple levels of totem hearsay. So there really, in practice, isn't an evidentiary standard. And so these statutes can be used as a weapon in whenever you have reciprocal hostility between divorced parents in a high conflict case. Particularly with the amendment, I think this abuse addresses the abuse very clearly. Nobody is saying that an abusive parent shown to be abusive should have 50-50, nor does this bill do that. And so I think we're chasing a red herring with the abuse issue. With that said, I would just say our state has lofty ideals. Parenting rights are protected under Article 2 of our state constitution. We have case law describing a spirit of equality that pervades the entire state constitution. The reality on the ground with parenting is that's not the case. Jumping ahead to testimony we heard earlier, we've got 127K backlog of cases. We've got overworked judges. I've sat through a 5-day parenting hearing, not my case, where we're arguing about whether a cold leftover Chinese food is being litigated. And that's stupid. You should come into court and a judge should ask, do we have an agreement? And if the parents have an agreement, we're done. Now we're off the 127K docket. And if the answer to that is no, then the judge should say, can anybody give me a good reason why I shouldn't award 50-50 parenting time? And if the answer to that is no, congratulations, we're off the docket. Gets rid of the backlog. And if the answer to that is yes, then somebody should start talking, one of the two parties, with some valid reasons, and whether the evidentiary standing at that point is preponderance or clear and convincing, you can exec that out. But if we just have a presumption that this is how we're doing it, absent a good reason to do otherwise, we can clear the docket. And I would just finish that this would have gone a long way towards preventing the tragedy of my own case, and to address what other states are doing. What other states are doing right now, California, Michigan, multiple other states, is trying to figure out what New Hampshire did in my case. And because we didn't get it right from the beginning. And if we just have this, I wouldn't be in a 6.5-year protracted court case. And so let's pass this and just make it easy and clear the docket. With that, happy to take questions.
Any questions? Seeing none, thank you. Seeing
Wait.
one, thank you, Representative Moulton.
Thank you, Mr. Chairman. So are you for or against this?
I am
bill?
absolutely for this.
You're for this. Okay, thank you.
Thank you for your testimony. The chair recognizes Attorney Richard Head from the Judicial Branch.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. What my comments are really into in drafting comments. So, for example, and I'm talking about the bill as introduced, and I did. I was able to get a copy of the amendment, and I have a couple thoughts on the amendment. I think the amendment is an improvement in terms of drafting. But on the original bill, on lines 4 to 5, it references in accordance with the best interests of the child pursuant to RSA 461A:21A. That's a very narrow definition of best interest of the child if that was to be used. 169A:21A is, excuse me, simply says support frequent and continued contact between child and both parents. That's not the full definition of best interest of the child. And really that should be a reference to RSA 461A:6, which is the definition of best interest of the child. In most of the rest of the first part of section 1 and the amendment, it references equal parenting time. So we have a lot of words in 461A. We have decision-making responsibility, we have parental rights and responsibilities, we have parenting schedule, and we have residential responsibility. We do not currently have equal parenting time. So now we have a new phrase that's being introduced into the mix of things. We all may say, well, we all know what equal parenting time, that's sort of obvious. If we all tried to write down separately what equal parenting time means, that might be something different. And now a judge is going to be interpreting that. There is no definition contained here as to what equal parenting time means. So for example, Concord School District has 177 days in the school year. So that sort of tends to get boxed up with one parent or another, depending on their geography. What does it mean when we're talking about equal parenting time as compared to parental rights and responsibilities? Or when we're talking about residential responsibility, because one of the rules of statutory construction is, well, we're using a different word, so we must mean something different. It's not clear what it is we mean when we're using that particular word. And we already have sort of policy goals that are stated in 461A. We support frequent and continued contact. We want to share both parents to share in rights and responsibilities. And we want both parents to have joint decision making, and those are in the best interests of the child. So this just adds another layer without a lot of definition. In the bill as introduced, which I believe is, if I'm reading it correctly, in the amendment is taken out, which I appreciate it. I think is a very good move. On page 2 of the bill as introduced, lines 4 through 12, talks about access to records and what happens if access is denied. And it says on line 7, upon the written request of the parent, the court shall, upon its finding that the individual, professional, public, and private institution or organization is denied such request without cause, order that party to stop doing stuff and to award fees. That is not a party in the litigation. It's somebody who is external to the court, and this would require us to make findings to somebody who's not involved in a proceeding in front of the court. That is not something the court can do. And then sort of they don't have an opportunity to present, to talk, to do anything, but orders are being issued against them apparently without their knowledge. I believe that is corrected in the amendment by simply dropping that part of it out. In both the amendment and the bill, and I'll talk about the bill as introduced, lines 14 to 15 talks about, if you go to the introduction, the presumption that equal parenting time per calendar year is in the best interest of the child may be rebutted. And then 14 and 15 says, if one of the parties does not request sole, primary, or joint responsibility for the child. That at least, I have some troubles interpreting exactly what that means when we're talking about equal parenting time, but one of the parties simply does not request sole, primary, or joint. That appears to be a rebut to equal parenting time. And truthfully, I'm just confused as to exactly how that would be applied in terms of a court trying to interpret that language. And with that, I would conclude my comments, but be happy to answer any questions.
Any questions, Representative Nelson?
Thank you, Mr. Chairman, and thank you for taking my question. Is there any way we can find out data on how much time presently is awarded? Like, I don't know exactly how to word this question, but
So we don't,
okay, yeah, you probably know what I'm asking.
So thank you for the question. We do not, in our database, have a way of extracting out orders of time awarded. So we don't have a database that we could extract that from simply because that data is not inputted into it. We know how many cases are filed. We know, some limited data, but we don't input all of the data from an order into our database. So then we can't extract it.
Okay, thank you.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. To your knowledge, has any state in this country defined equal parenting and what that means?
So thank you for the question. I did not look. I only looked at the New Hampshire statutes to see if there was a definition. I did not look if there are definitions around the country and if they're the same.
Thank you.
Representative Bickford.
Thank you, Mr. Chairman. Thank you, Mr. Head. In 2005, we passed presumption in favor of shared parenting rights bill. One of the differences was that we used the definition of comparable instead of equal. Used the word comparable. Would that be helpful? That passed the committee 4-0, went on the consent calendar.
I think if you use the same words that we've used before, those tend to have had some time to be interpreted. I'm not sure exactly, and I apologize, exactly what change you would be proposing. Instead of equal, you would say comparable?
Yeah, utilizing the word comparable as opposed to equal. That's the difference I can see between the two bills in 2005 and the one now.
Yeah, truthfully, I would have to think about it. I haven't looked at the I haven't looked at how comparable has been interpreted in that
All
context.
right. And if I may, I'd like your remarks. Can I have your written document of your remarks?
So I've got,
I'll take a copy.
Pen scratch notes.
Well, can you do them over then? And submit them to the chairman for us to review?
I can certainly try.
Because I thought you had a lot of good information in there. to help us with.
I'm happy to try to put it into an email to the
Thank you.
committee.
Appreciate that.
Representative Ball.
Thank you, Mr. Chairman. I am admittedly new to all of this, so I would just like to question, since there seems to be an not able to define equal, is there a reason why we just don't say 50-50 parenting?
So thank you for the question. I think conceptually equal means equal, and I understand what equal means. Is it everybody has to have the same number of hours? Is it time spent with the child, but not necessarily residential? Who's keeping track of the time? So equal is a great word. Equal what? Is it it's probably not residential time, because that's already sort of in the statute as something we're supposed to aspire to. Is it, what's the other word? Oops. Hold on. I lost my place. Now I have a clip. That's my problem. Is it, so we already have sort of parenting schedule, parenting time, frequent and continuous contact, and residential responsibility. So if equal is supposed to be essentially, are we talking residential responsibility, so that we're equal time in the respective homes? Okay, that's fine. If that's what's meant, just say it. If it is time spent with the child, okay, then I think just say that, and then sort of how do we measure that? Or is it something else? And I don't know what the something else would be. But I think it's just a question of saying, what are we making equal? What's the math formula look like to come up with 50-50?
Follow up. So if this was clarified to say equal time with parents and not that other frequent visiting, if it said these are the options, you either go to a 5-2-5-2 schedule or a 2-2-3 schedule, or so that we know that in a month of 30 days, it's 15 days you're with mom and 15 days you're with dad, and how mom and dad decide whether you're going to go every other week or whether you're going to make up time in the summer, but somehow the days of the year are divided and you spend equal amounts of time when you look at the overall year. If it's at all possible, because then I guess when I look down and I see where it says what you were questioning about, unless one party says they can't do it and they're not looking for that, it could be that that person lives out of state, they're working out of state, or for some reason can't take it on. So I could see what that would mean. But are you saying that the bill would be good if we could just define that one equal parenting? What exactly is that?
Sure. Thank you for the question. And whether you define it or not, the question is whether you want to have control of that definition, or if you want that to sort of evolve over time with the court system. They're going to have to define this because there's not something more specific in the bill.
Okay, thank you very much.
Representative Nelson.
Thank you, Mr. Chairman, and thank you again for taking my next question. With that being said about struggling to find a definition of equal time, what is the definition of frequent? Because that's not an exact measure as well. So how does the court determine exactly what frequent is?
So thank you for the question. I truthfully did not poll or look into that before coming here today, so I don't know off the top of my head.
Seeing no hands, hearing no voices, thank you for your testimony, and
Thank you.
we'll look forward to that transcription from Chicken Scratch. Chair recognizes the Honorable Betty Gay.
as a person, thank you for taking my testimony. As a person who's extremely concerned about domestic abuse and how it is handled in court, I may sound unusual in that I really support this bill for multiple reasons. Currently, there is no requisite requirement for a judge to consider domestic abuse or even any other reason why somebody should not have parenting rights. Protracted court hearings have been reduced in the states that have adopted equal shared parenting. They have been reduced over 50%. In fact, in one state, they have actually an entire law firm that hired many people has gone out of business. This promises to save parents a huge amount of money. Once you stop fighting about, that's the main thing. I'm sorry I can't speak well, but I'll just try to get my ideas across. That's really what mostly people protract their legal fights over, is their children. The most valuable thing we have is our children. So once you settle that, there's not a lot more to fight over. With the great reduction in charges of domestic violence, this also frees up our agencies that investigate domestic violence so that they have more time to investigate the ones that are much more serious. One of the things that I was really concerned about was, how do you prove, how do you prove there's domestic violence? Currently, like I said, under current rules, we all know horror tales where it wasn't even considered. The judge just decided that one person would get 100% of the custody, and they didn't have to consider whether that was safe or not. So worst came to worst, they would give a child to a domestic abuser 50% of the time. Right now, it's happening 100%. So the burden of proof, that isn't some esoteric thing out in the clouds. There's some genuine, concrete ways that you can determine whether a parent is not safe for a child to live with. And there's a history of crimes and assault and DV. That's recorded. You can read court documents to see if there's conditions like, is there a place for the child to actually stay with this person? Is there safe housing? Are the parent, have they ever shown any kind of behavior that sounds like they really aren't up to parenting? Then there's also medical records, because if this person is an abuser, there should be some medical records because they've hurt somebody. I'm kind of wryly amused at not being able to just discern what 50-50 parenting is. Coming from a mathematical background, my background is engineering, equal is 50-50. So I really think that's not hard to determine. And it's nice to give the parents some flexibility to figure out how to do those 15 days per month. That's fine. We don't have to tell them exactly, but we have to say that is the goal. So I appreciate very much your attention.
Thank you, Representative. And are there any questions?
Thank you.
I do not see any, so thank you very much. And the chair recognizes Ed Bryans.
Thank you, Honorable Committee. My name is Ed Bryans. I'm from Marlborough, New Hampshire. I respect this committee's time. I'm so happy to hear some of the people, Representative Gay, going over the drop in domestic violence claims from the states of Kentucky, West Virginia, and Arkansas that all have a shared parenting bill. Their lawyers and judges can now address issues that are real. I want to teach this committee a couple coined phrases that some of us that have been through the system use. One of them we call false domestic violence claims the silver bullet. The silver bullet is when a claim is made, parenting time is taken away from one person to the other, and it sets the pace for the final outcome of a hearing. The other coin phrase we use is being a Disneyland dad, when a father who is fit for every other weekend to visit with his child only has 4 days a month with that child. You don't spend that time working on a child's homework, teaching them discipline, giving them chores, normal things that a father maybe would do. But instead, you want to make that 4 days a month as enjoyable and fun with that child. And you're going to spoil the kid. So you end up raising a spoiled child. Again, 10 years ago, I went through a family court matter. The end result was 50-50. Here I am 10 years later with a 15-year-old daughter that I am so grateful to share time with her mother, because boy, she has a lot of drama. But we don't, at this point, look at, she stays an extra day at mom's house. She's got a sports event. She doesn't get back till late. You know, it's 59, 41%. It may be 30% one week. It may be 75% another. But the fact is that the mother and I communicate, and we do what's best for our child. Going into the family court arena, that's exactly what it was. It was drag all the dirty laundry, all the most negative things we can find about each other, because the system is set up to be a winner take all. And he that wins the prize has the child. I'm very different than my co-parent. My ex is very organized, very methodical. I may be a little bit more adventurous. My daughter is the best of both of us. I've been involved a little bit with the political arena. My daughter surprised me one day, put her name in and ran for and became the school president. She's the captain of the basketball team. You know, I'll take my daughter to a rope swing. Her mom's, oh no, she's going to get hurt. But she's adventurous, she's strong, she's determined, but she's also organized like her mother. So if it wasn't for that 50-50, I might have the wonderful child that I have. And I just hope this committee will support this bill and finally see it go forward.
Thank you so much for bringing that to us today. Does any committee member have a question?
Thank all of you.
Thank you so much.
Thank you.
This will conclude the hearing on House Bill 185. Let me just mention to the committee and also to any bill sponsors who may be out there, this committee will not be meeting next week, but we will be meeting on March 7th, and we will exec all the bills we've heard today and all the bills that we have heard in the past that we have not yet execed. So therefore, if people want to write amendments and do thises and that's, the exec session is 2 weeks from today. Now the chair opens the hearing on House Bill 455 relative to creating a new state cause of action and special findings for abused, neglected, abandoned children seeking special immigrant juvenile status under federal law. The chair recognizes Representative Laura Tulesky. Sorry, I know that.
You were there.
I'm fading fast here, but thank you. And I think you want to tell us what you'd like us to do with this bill.
Yes, thank you.
For our conversation. So thank you.
Thank you, Mr. Chairman. Thank you, committee, for having me today. I'm going to start. My name's Laura Tulersky. I'm represent Hillsborough 11, which is Nashua's Ward 8. I'm going to start right off by telling you that I have communicated with the chair and vice chair that I hope the committee will consider retaining this bill to learn more about the issue. I know that the language as written in this bill is not going to solve the problem. And I think that can save us a whole lot of time here if we just take that bill and stop looking at the text, but just use this opportunity to learn a little bit more about special immigrant juvenile status and what the problem might be. So I hope you can take a minute to listen to me while I give you a little bit of background about how this came about. And then I know that there's people who are going to be testifying after me. Unmarried non-citizen youth under the age of 21 in the U.S. can be classified under federal law as special immigrant juveniles. Congress created this classification for vulnerable youth who have been abused, neglected, or abandoned by one or both parents or their guardian, and whose best interests are served by not being returned to their country and instead remaining in the care and custody of the nominated guardian. SIJ classification and protection has been available since 1990, when Congress passed a law to assist these youth with obtaining lawful permanent residence through a special immigrant visa. This classification itself does not grant citizenship or even lawful residence, and requesting this federal classification is a two-part process. Our own state courts are step one, since it is the purview of the states to determine whether a child has been abused, neglected, or abandoned, and what is in the best interest of the child. Pursuing this status requires a judicial determination regarding the necessary criteria. Without this state court determination, a youth cannot seek the federal law path to SIJ classification, protection, and stabilizing status. After the state court findings are issued, the second step is to then apply for this SIJ classification, and it is the federal decision makers who review the application and make a determination. In other words, the federal government has the sole responsibility to regulate immigration, but certain responsibilities have been given to the states, such as determinations regarding abused, neglected, and abandoned children. It is the state court that must provide factual findings about a vulnerable child. Why did Congress give states this responsibility? Because the protection, well-being, and determining the best interest of children is directly in the wheelhouse of our state courts. It is important to remember the New Hampshire courts are not giving these children immigration status. Notwithstanding New Hampshire state court determinations regarding dependency or custody of young non-citizens, they can still be denied SIJ classification, but it is the federal immigration authorities that will deny or accept the special immigrant juvenile petition, not the state. Congress defers and relies on the states to make findings regarding dependency and custody of youth and appropriate state court proceedings through which these vulnerable youth may seek these findings. So that's the background. Since learning about this issue and drafting the bill, I've met with several immigrant attorneys and advocates, and every one of them agrees that state law provisions are needed to provide for appropriate proceedings and determinations for these vulnerable youth. And the new statutory provisions and modifications must fit within the New Hampshire framework. Also, since this bill was drafted, information has come to light concerning issues arising in the adjudication of these matters for minor children within the existing framework in New Hampshire, as well as an increased scrutiny at the federal level of orders issued in cases for older youth. And for these reasons, and to allow more clarity to come of these issues, it seems most prudent to retain and revisit this legislation in the fall or again in a future year. So why should we care about this issue? There is some inconsistency among New Hampshire judges in consideration of the cases filed on behalf of these vulnerable youth. Some judges issue findings, while others don't see it in their authority. Children, particularly those in the group, are the most vulnerable and are at risk for further abuse and trauma, and run the risk of homelessness, prostitution, forced labor, or trafficking, and we fail them by not protecting them. I appreciate the time that the committee has given to this important issue today. I believe you will hear from others who may have thoughts on retaining the bill to look at the issue further in an attempt to provide guidance and to provide the structure needed to solve this problem in our state. Thank you, Mr. Chairman.
Would it be possible for you and the other members to get us copies of documents so that as things wind down here in the spring, we'll be able to open up our folders and start reading through what you have. So when we have a day to just get everybody together and have some fun with it, we'll be pre-informed a little bit.
Sure. I think you'll hear from different parties that may be interested in being part of that conversation.
Any questions for Representative Zaleski?
Oh, thank you, Mr. Chairman.
Representative DeSimone, please pass 2 of your Altoids down to the gentleman in the far end. Representative Bickford.
Thank you, Mr. Chairman. Thank you. I'm pretty lost on all this immigration stuff. It's right outside my knowledge. Now, 21. I see the age 21 in this case, and generally, of course, New Hampshire, we talk about 18 being age of majority. Could you explain that to me a little further?
Sure, that was part of the question that we had when I was going to file the bill, and that's some of the questions that we're trying to work out to see if this is the right application for that. So,
Oh, okay, so you can't really answer it?
no, other than the federal law allows up to 21.
Okay, thank you, though.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. On the same line of the age of 21, it says here, child means an unmarried person, and I'm going to go back to a bill that we had a couple of weeks ago. And in the state of New Hampshire, with judicial and parental consent, you can be married at 16. Not a good idea, but you can be by law. So do you really think that 21 should be the age of an unmarried person?
I'm just reporting on the fact that the federal law allows up to the age of 21 for this immigration status.
Thank you.
Yep.
Thank you, Representative.
Thank you.
Chair recognizes Mr. Bruno de Brit, is it, sir?
Bruno Brito. Bruno.
Okay, this is Portuguese, right? All right, you got me, brother. All right. Please, sir. You may begin when you're ready by pushing the button, and that activates the microphone. Good.
All right. Good afternoon, Mr. Chair. Good afternoon, members of the committee. So I have provided you with a sheet of paper of some important documentation pertaining to special immigrant juveniles. I also, for some of you, so you just open your camera. I'm sorry, because there was a lot of paper. I didn't want to print out a lot of paper. So if you open your phone, you can scan the code and it will pop up with the PDF. So I'm trying to save, some trees here. But I also sent it to your emails as well. So I know I said I'm going to be 5 minutes, but I'm going to be a lot briefer than that. So again, my name is Bruno. I am president and executive director of the New Hampshire Brazilian Council. We are a nonprofit organization who assists immigrants and other individuals, mainly in the state of New Hampshire, but in other states as well. I am also an immigration attorney. My license is active in Massachusetts, and in New Hampshire, it's not, I have it as, not active. So I still pay my dues. But for the purposes of special immigrant juveniles, I have a lot of cases, mainly in Massachusetts, and under the federal statute, under the CFR, ACFR, it allows anyone who is under 21 to apply for a special immigrant juvenile with USCIS. But in order to do that, they need a predicate order from the state courts stating that it is not in the best interest to return to their home country, that they have been either abused, abandoned, or neglected by one or both their parents. And typically, what happens is, in the order, we ask the court to either to be responsible for that child, or 99.9% of the time, we ask the court to denominate another individual, such as the other parent, And typically it's the mother who to continue being responsible for the child. And in New Hampshire, unfortunately, we are having a lot of issues with getting special findings. So the courts, they are in conflict on how to issue these, and some of the attorneys also do not know how to move forward. So we are all lost in New Hampshire on how to get special orders here. And this bill, I think, like Representative Terlersky is trying to, take the first step to come together and hopefully solve the issue we currently have in the state. So the documents that I have provided to you, the first one, the USCIS definition, it simply provides what the definition of a special juvenile is. And if you also click on the link, it brings you to the web page, which is going to provide the same information as the PDF. It's going to show you all the requirements for the state court's orders, the eligibility. One of the questions was whether the person is unmarried. At a state court level, the state can still issue the order, but under federal law, that would not be accepted. But the state can still issue these. Essentially, would be a dependency order to that child, and the second QR code states the purpose of why this law was created. Essentially, there are a lot of abandoned, abused, and neglected children all over the world. And a lot of these children, when they came to this country, they didn't have a say on whether they wanted to leave their school in their home country, their friends, all they knew behind to come to a new place, and like a whole completely different life. And the third one is the CFR, which provides the actual language of the federal code on what it is. And the fourth QR code at the bottom, so it provides a guide from the American Bar, the American Bar Association, the ABA. It provides a guide for state courts and lawyers across the country. And I also have provided a sample of the petition of, like what I typically file in Massachusetts. Thank you.
Any questions? Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. How many special immigrant juveniles do we have in New Hampshire, to your knowledge?
That is a very good question. So it is hard to say because a lot of immigrants, they live in fear. So they live in the shadows. And it's very difficult to give you a number. But I'm going to give you, like a number from I forgot. So it's part of one of the programs from the chamber in New York. It's New American, and I forgot the name of the report. I'm so sorry. So we estimated that we have approximately 15,000 undocumented immigrants in the state of New Hampshire in 2019.
Follow up.
And is that juveniles or all undocumented?
So all undocumented.
Thank you.
Representative Petrino.
Thank you, Mr. Chairman. Mr. Chairman, would it be appropriate for me to acknowledge Attorney DeBrito as a former student of mine at Nashua
Yes,
Community College?
yes.
He came to my class with limited English, a new arrival to America. He was an incredibly hard worker, and I'm very proud to see that today he's an attorney sitting before us. So,
Yeah, thank you. Yeah, so he taught me how to read. So thank you.
Anyone else? For Representative Petrino's prize students. Looking forward to seeing more of you when we do some hard work on this later this year. Thank you, sir.
Thank you.
Chair recognizes Olivia Bensinger.
Good afternoon. I think it's still on. Okay, great. Perfect. Thank you, Mr. Chairman and members of the committee for allowing me to speak today. My name is Olivia Bensinger, and I'm an immigration attorney and other attorney over at Shaheen and Gordon here in Concord. I was happy to have to be able to walk over here today. As Representative Tulersky explained in her opening remarks, Special Immigrant Juvenile Status, or SIJ as I'll inevitably call it as I talk today, provides a path to permanent residency for non-citizen youth who have been abused, neglected, or abandoned by one or both of their parents. That path begins with a determination made by a juvenile or similar court that the child is under 21, that the child is unmarried, that the child is dependent upon the court, that the child has been abused, neglected, or abandoned by one or both or other, by one or both of their parents or another caretaker, and that it is in the best interest of the child to remain in the United States. As the federal government has delegated these responsibilities for the findings to the state court because it is within their purview to make best interest findings for youth residents of their states. And because these findings are based upon state law, the mechanisms vary from state to state. The bill presented today identifies an issue that presents a discrepancy between New Hampshire state law and the federal requirements. Under New Hampshire law, a child may only be dependent upon the court if he or she is under 18 or over 18 and incapacitated. Federal immigration law defines the child as anyone under 21. This bill intends in part to bridge that gap and to bring New Hampshire into compliance with its obligations under federal law. There are many other procedural difficulties with SIJ that are winding their way through the New Hampshire courts right now. Lawyers in the state have been seeking these special findings through 3 primary mechanisms for the past probably 20 years now, through guardianship petitions, through 169C abuse neglect petitions, and through parenting petitions. In recent months, the New Hampshire Circuit Court has stated a firm preference for the use of the guardianship petition because it does not require DCYF involvement like the 169C petition does. Some judges, however, are not aligned with the court and finding that they either have no authority to issue such findings in a guardianship hearing or just simply decline to do so. Further, guardianship is not the appropriate vehicle for every case, as some children's need for dependency on the court varies in form. These jurisdictional issues, along with some service difficulties, are the main obstacles to efficient administration of these cases in the New Hampshire family courts right now. And this bill does not address each of those difficulties that we find ourselves facing as attorneys who represent these clients. I agree that there needs to be guidance in the statute on the proper procedure for seeking these special findings. This bill attempts to do that, but ultimately presents additional issues. In my opinion, as it is of Representative Tulersky's, it is in the best interest to retain this bill for work in the fall or at a later time. There are, as we try to work out through the court system, some of the procedural issues that we're facing with the courts. Additionally, approximately two weeks ago and after the introduction of the bill, the USCIS, which is the United States Immigration Citizenship Services, Citizenship and Immigration Services, sorry, I said that backwards, has made clear that bills like this one, which seek to impose a new cause of action solely for the purpose of obtaining special findings, will trigger additional scrutiny by them when they are reviewing these immigration petitions after the family court process. And they may not ultimately provide the protection that everyone seeks to achieve for these vulnerable youth. That is the last thing we want when it's not the purpose of amending the law. I thank Representative Tularski for putting her voice behind this fight and for seeking to help abused, abandoned, or neglected non-citizen youth seeking refuge in New Hampshire. I, again, support these efforts and hope that we can work them out over time and into the fall. We certainly look forward to working with the committee to resolve this discrepancy in the law and working out the procedural issues we're facing right now in the family courts. Thank you.
Any questions? Seeing none, thank you, Counselor. Chair recognizes Attorney Richard Head from the Judicial Branch. Remember, I would bet the ranch we're going to retain this, so input us some stuff along the way.
Thank you, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. In light of your comments, we do support retaining this bill. We appreciate the sponsor bringing this bill forward and the advocates working on it. But and it's an area which there does need to be some clarification, and we'd be happy to help with work on the bill, and support retaining it. Thank you.
Thank you. And Beth Morganson from DCYF, available for questions. You said that.
I did. So, because this is really, even though it is abuse, abandonment, neglect, this is really not a matter of DCYF's purview. In fact, because we're dealing with people over the age of 18. But since the bill's being retained, I don't really have any comments unless you had any questions of me with respect to this bill.
Seeing none, thanks for coming.
Okay.
Now, this concludes the hearing on House Bill 455, and with the consent of my vice chair, this opens the exec session on the same, so the representative can watch the bill retained in real time. Chair entertains a motion. Representative Long.
On House Bill 455, I'll move to retain.
Retain, and I would like a Republican to second it because, there's a lot. I saw you first. Representative Nelson.
Thank you, Mr. Chairman. I second.
Okay, second. Any discussion? We've already had it. The clerk, please call the roll on House Bill 455. The motion is retain. Moved by Representative Long, seconded by Representative Nelson. Yes.
Chairman Pearson. Representative Long.
Yes.
Representative DeSimone. Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
Motion to retain 15-0. One absent.
Motion carries 15-0, and this concludes the exec session in House Bill 455. Add to the pile of retained bills. We're going to be busy this fall, but it's worth it, huh? Now, Chair opens the hearing on House Bill 499. Let me read the title, requiring the rules of evidence to apply in family court cases and relative to admission of certain evidence in family court proceedings. The chair recognizes the bill's prime sponsor, Representative Holt.
Thank you, Chairman. I'm going to hand out two things.
Please.
this is the last one for today. Yeah.
Thank you, Chairman, members of the committee, Representative Hole. Speaking on behalf of House Bill 499 relative to rules of evidence in family court cases and relative to the admission of certain evidence in family court proceedings. Before you as well is an amendment 2023-091H. I will be speaking to both the bill as well as the amendment. Between the time it was drafted, which was late December, during that hurried period, the bill was drafted during that hurried time where OLS was trying to finish up in late December. The section where this was put into law was in the judicial rules as opposed to, and it actually would have created a conflict with what was in statute under 169C, and the request was really to deal with having rules of evidence for cases within the DCYF, right, in the child neglect and abuse statutes. So under current law, under 169C12, there is a carve out, and I think I can read it for you real quick, that the rules of evidence do not apply. That's where it goes today. And part of that is maybe there might be a good reason to not apply rules of evidence. It's hard to figure out what to do with a young child who has relative information in an abuse case, and DCYF needs to testify on that. However, there should be some standard by which evidence is presented in these cases, and this bill is intended to deal with 169C12, okay, which I quote, in any hearing under this chapter, the court shall not be bound by the technical rules of evidence and may admit evidence which it considers relevant and material. Evidence of prior founded or unfounded reports of abuse or neglect shall be admissible in the proceedings under this chapter in order to establish a relevant pattern or course of conduct. That is the current law today. The amendment in front of you actually replaces all of that. We should have some standard by which evidence is going into the courtroom. What we have seen is cases where people are denied the chance to have information that is beneficial to them because the judge has complete discretion. That sets up a non-due process type process, I guess, right? There is no due process if all of the evidence is slanted in favor of the state pursuing a respondent. The next section of this, which is 2, and this was asked for, what if there needs to be a waiver? And I drafted in lines 14 and 15, if the judge has reason to believe that applying the rules of evidence shall adversely affect the case, the judge may waive the rules of evidence and shall note in the file the rationale for this decision. I believe when you do shalls in statute, it's a requirement always, right? It's either may or shall. Shall is, right, the rules of evidence shall be applied. But if there's a reason that the judge has, and this can be in consultation with either the attorneys, has reason to believe that the rules of evidence would be adverse to the hearing, allowing the judge to waive those rules would be prudent. And then he just needs to note, he or she needs to note why in the case they did that. For instance, it's a pro se respondent, and the pro se respondent doesn't necessarily know all the rules of evidence, so the pro se respondent could in fact trip himself or herself up on trying to respond to an accusation because they aren't familiar with court rules. There might be a case where the state, as the plaintiff, has compelling evidence that would be difficult to admit because it's a child in this case, and the child can't testify themselves. We don't want the child to testify. So now it's secondhand information, but it needs to be presented because it's relevant to the case. So the judge has that level of discretion in Section 2.
Excuse me for 1 second. Are there extra copies of the amendment around? Could you give one to Attorney Head? I think since,
There should be 30 copies or
there
so.
should be, yeah. How many would you like? Okay. Because I think this amendment really is a good faith effort on the sponsor to take into
So-
account a variety of things.
Right. The original bill, when drafted, put it into court rules, but it was so broad it would have covered all family court proceedings, and it was never intended.
I would suggest you suspend for just a minute.
Sure.
Okay, back up about 3 sentences and start again.
Sure. The bill as filed, the original bill, OLS drafted into Section 490-D, which has to do with oversight of courts. The issue is it covers all family court proceedings, and there are other things that go on in family courts other than child neglect and abuse cases, right? This would have impacted all cases relative to divorce proceedings, for instance, some other things. This is really about a narrow section of that, which is why the language actually should have been put in 169-C to address the cases under 169-C. And then there was a may and shall, right, level of drafting issue that was corrected in the amendment as well. So I would ask that you would consider and debate on the amended version of 0619H as opposed to the bill as filed. And it would be easy as the committee to default back to the bill, but you've all been provided copies of this. We've provided copies to those in attendance so that it can be discussed on this. And it's simply establishing a baseline so everybody knows the rules of the game going into a court proceeding. With that, I'll close my testimony.
Any questions for Representative Hall? Representative Raymond.
Thank you, Mr. Chairman. You should just assume I have a
I
question.
would suggest you alternate arms, otherwise you will wind up being lopsided. Thank you.
It's possible. It's possible. Thank you, Representative Hull, once again for coming before us and for catching that legal reference right away, because that was one of my big circled questions from before, and that changes my reading of this significantly. So now I'm back to a question I'm going to ask you about the amendment, which is basically the same thing. My question is, it seems to me that your Roman numeral 1 and Roman numeral 2 are kind of in conflict with each other, and I'm wondering if you can speak a little bit more about it, because Roman numeral 1 says that the court shall admit any evidence or testimony offered by the respondent. But then number 2 says the court shall apply the New Hampshire rules of evidence unless they waive it and give a reason why. So does that mean that the respondent can have whatever they wanted admitted, but then DCYF or therapists or whomever are held to a different standard than the parent? Or are you saying that they will admit it, but they have to have a footnote saying why they admitted it? So I'm confused about how the two parts work together.
Merged together. Great
Yes.
question. Thank you. So
Yes, that is a question.
I think I understood it. And to answer your question, how do sections Roman numeral 1 and Roman numeral 2 merge together? And I think we need to establish what is the rules of evidence. I would expect that if DCYF is at a hearing, their attorneys are going to understand the rules of evidence. They will be able to follow the rules. They can go to the judge and say, I need to waive the rules of evidence because of X, right? I have compelling reason to waive the rules, and they can make that motion to the judge. That's going to be easy for an attorney to do. Likewise, the respondent or their attorney could do the same thing. This establishes the floor. We all are going to use the rules of evidence. So we have some process. We have some collective set of standards by which evidence is being applied. Both parties can ask for a waive of the rules. the only thing that is required when that happens is the judge has to note why he or she is doing that. And I think that's the footnote in the case that says, look, I believe that DCYF had compelling evidence, and okay, but it didn't comply with the rules, the standard rules of evidence. So I admitted it because it was relevant to the hearing and would have adversely affected the outcome. And it doesn't, that's neutral language. It's not right in favor of the plaintiff or the respondent. It's purely neutral outcome because the judge may see something in that evidence that is valuable to making a decision. So does that help you understand how they merge together?
No, it didn't. I got halfway there. So I understand, because I think you spoke to number two. Number two
Yep.
is the rules of evidence shall apply unless there's some compelling reason why they shouldn't. And so I'm hearing you say either the respondent or DCYF can say, here's why it doesn't apply, and the judge can make a ruling. But then number one says, except that doesn't apply to the respondent can have whatever they want admitted.
So,
Right?
yes.
Okay.
So we're in sync, and I will explain why one is left for the respondent. So this is a constitutional issue. I don't have my, I do, hold on. The New Hampshire Constitution, right, under Part First, Article 20, I think, is very similar language about all proofs favorable to them, right? And that has to do with criminal cases, but in this case, it would apply as well.
Did you say you think it's Article 20?
I want to say it's Article 20. Let me just check real quick. I don't want to misquote
I'm happy
the
to Google that.
Constitution. No, it is not 20.
Oh.
It is rights of the accused, 15, right? No, every subject shall have a right to produce all proofs that may be favorable to himself. Sorry, it's written in single gender at that point. To meet with the witnesses against him face to face and to be fully heard in his defense by himself and counsel.
And okay, and that's regarding criminal charges, yes? Or it doesn't specify?
It doesn't, and both in all of Part First, right, of the Constitution and Bill of Rights, it does address civil cases. It talks about property transfers. It talks about charges over $1,500, right, requiring a jury trial. So I would argue that in this case, right, where we're talking about child neglect and abuse accusations, and we're talking about potentially the removal of home, which is a punishment on par with a felony level offense, at least in my eyes.
Well, it's,
right?
it's certainly traumatic. For
Right.
everyone
It's
involved.
traumatic for all parties involved, including the child. If the state is getting that involved into the case, or right in that involved in the family through this case, there is merit to the respondent having access to all proofs that are favorable to him or her per the Constitution, Part First, Article 15, which is why it's drafted. I did not quote verbatim, but it is drafted to be very similar to that style of language. And then remember, the state has effectively unlimited resources in a DCYF case. The respondent does not. The respondent has what their checkbook allows or what they can borrow or what their friends will give them. That is a very lopsided case when it comes to a court hearing. It's not two parties debating on an even financial playing field. Almost always, the respondent does not have access to the same resources that the state does.
Thank you for taking my question. I appreciate it.
Sure.
Any other questions for the representative? Seeing none, thank you.
Thank
And
you.
the chair recognizes Attorney Richard Head.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. And I appreciate the sponsor's clarification in the amendment, and I'm just going to speak to the amendment as opposed to the original bill on the assumption that is going forward in that way. The amendment does help clarify in terms of limiting it to the section or limiting it to 169C. I do believe, notwithstanding the representative's explanation as to why paragraphs 1 and 2 are not inconsistent, they are inconsistent, and paragraph 1 goes substantially beyond what the Constitution provides in Part 1, Article 15, The amendment in paragraph Roman 1 would read that the court shall admit any evidence or testimony in any form offered by the respondent, in a family division case which the respondent believes will be favorable to his or her case. It still talks about family division case, but it's in 169C, so I would have to assume that's limited to 169C. I think that needs to still be clarified, but the expansion is that there shall admit any evidence or testimony in any form. So there's no capacity for the judge to apply the rules of evidence, for example, as to relevance. And so if a respondent believed that reading 6 U.S. Supreme Court cases front to back was favorable to his or her case, they could do that, I think, under this section. They could, because it requires the court to admit the evidence in any form offered by the respondent. And all the respondent has to say is, I believe this would be favorable to my case. So I think it is, as written, extremely broad and does not allow the court to apply any rules, but simply requires the court to allow the testimony to occur in whatever form for however long it may actually take. With regard to the second paragraph in the amendment, which would again apply only to 169C, truthfully, I did not come prepared to talk about why it is that the statute in its current form says that the rules of evidence do not have to apply. And there was probably a very good reason back when the statute was passed. It's been amended a couple times, 1979 and 2017 is the most recent. And truthfully, because I didn't have the amendment, I didn't go back through and try to identify exactly what was the concern that was being addressed at the time. And I'd be concerned without more information that we do try to identify that and learn as to exactly what was being protected. That said, in the phrasing of the bill, in the waiver language, it says, if the judge has reason to believe that applying the rules of evidence shall adversely affect the case, the judge may waive the rules of evidence. The judge does not look to whether or not information adversely affects a case. That's really a litigant's role as to what supports a case. The judge is interested in what is in the best interest of justice, or whatever the cases that's before him. The judge is not trying to figure out what is adversely affecting someone's case, because that case has to be presented to the judge. The judge is not presenting the case to the witness. So it should have a standard, if this is going to go forward, that the waiver would be, that the judge could waive the rules as justice may require, or some of the other more standard language that you see in the statute under providing the court with the authority to waive. I would, however, just pause in that I would like more time to be able to evaluate exactly why 169C12 exists in its current form, and talk to some judges as to sort of fact circumstances as to how it does apply. And I'd be happy to supplement, with the chairman's permission, my testimony in writing. With that,
I'd like to give you both a bite at the apple, not now, but later, on the way towards 2 weeks from now, when we will exec it. So to be fair to you to do that, I think that would be a good thing to do. And in the light of some of these things, I think the prime sponsor will have some things to do as well. So bring it on, both of you, and we'll do this in 2 weeks.
Great. Thank
Okay?
you.
You're welcome. Thank you. The chair now recognizes Keith Koenig from Waypoint.
Mr. Chairman, members of the committee, my name is Keith Kinning. For the record, I'm the advocate director at Waypoint. We sit in opposition to this bill as written and as amended. I would just reiterate everything that Attorney Head said. We have all the same concerns and the same concerns that Representative Raymond has. It's particularly concerning the first paragraph. I agree in hearing under this chapter, the court shall admit any evidence, personal evidence, intimate evidence, in any form offered by the respondent in the family division case which the respondent believes will be favorable to his or her case. So this is kind of like saying we're going to have baseball rules, but in the 5th and 6th inning, the visiting team can do whatever they want and the umpires can't do anything about it. And that just can't be. If you're going to have rules of evidence, the rules of evidence need to apply equally to everyone. I think trying to put the rules of evidence in the family court is literally like trying to put adult clothes on a child. There are reasons that they don't apply in a family court. There are many things children don't understand, from hearsay to other things. So, that's difficult. But even if you decide you wanted to do that and try to make that work, you can't have a system set up that the respondent decides what goes into the record and the judge just has no ability to stop that. I don't see how the court system, I agree with Mr. Head, somebody could decide to go on for 8 days admitting evidence. It'd be nothing the judge could do if the respondent said, I consider this relevant. So I find this very concerning. That's what I wanted to say. So thank you very much.
Thank you. Will you take any questions?
Sure.
Are there any questions for him to take? Representative Bickford, without having to clear your throat.
Thank you very much, Mr. Chairman. You said that rules of evidence should not apply. I believe that's what you said in family court.
Currently, I don't believe all the rules of evidence, they do not apply to family court for various reasons. And thank you for the question. But go ahead. I'm sorry, I interrupted you.
No, I was concerned about where you're going with that. You used the terminology about adult clothes on a child, but I'm trying to understand what rules do apply, what ones don't, and just to understand the issue here.
So thank you for the question. My understanding is, and I can guarantee you I'm not the perfect person to ask this question. I just know there's more flexibility in the family courts in order to accommodate the needs of the family court that are different from a normal court system. And so, as I said, if the committee decided they wanted to apply the rules of evidence, perhaps that's something that you could look into, but you can't apply the rules of evidence and then say, but it doesn't apply in certain situations.
Yeah, I got that.
Yeah.
Okay, thank you then.
Thank you.
Seeing no further questions, thank you so much. And making the assumption that the card that Representative Betty Gay handed in has her name on it.
How'd you know?
I'm good at this. I will call Representative Gay.
This will be faxed. Hey, Betty Gay. Thank you. I have my interpretation of this is that Roman numeral 2 is really, really important. And what I would do is I wouldn't have 1 and 2, I'd have 2. Well, renumber it. And it would say, in all proceedings under this chapter, the court shall apply the New Hampshire rules of evidence to any evidence or testimony in any form offered by the respondent in a family division case, which the respondent believes will be favorable to his or her case, to enhance the predictable, orderly, fair, and reliable presentation of evidence. To me, that's what it's really saying. We want to allow the court, the judge, to study anything and apply the rules. And if he thinks it's going to make the case it's going to twist the case, applying the exact wording, then he gets to change it and shall note in the file the rationale. We really would like records of when rules are changed. So to me, Roman numeral 2 says everything, and what Roman numeral says could be included in that sentence. It's just that you have the right to submit anything, but the judge is going to apply the rules of evidence and has the freedom to disregard the exact letter of the law of evidence as long as they note why they did it.
Give Representative Hole a call tonight, would you? Because he had to leave.
Okay.
Any questions on that? Okay, seeing none, seeing no one with a pink card running up to get in under the deadline. No, that wasn't a request. Thank you. Close the hearing on 499. You could have, you know, I mean, you could have, but. And that's it for the day, and have fun on tomorrow, voting, and maybe Thursday, snowstorm, and your week off, and I'll see you here in 2 weeks.